My lords, the court is muted, my lords.
Yes.
List to serial number 26, my lords. I appear for the petitioner, my lords. I pray for a day's accommodation, my lords. I have got some personal inconvenience.
Request of the learned counsel for the petition. The week's time of speed is granted. Case.
Much obliged.
List number 2, my lord.
Yes.
Serial number 41.
Yes.
Matter pertains to Mandamus direction to a representation dated 3/1/2022. Annexure D, E, and F, my lord.
Yes.
Now the matter has been listed before the first respondent on Friday at 10 a.m. at serial number 3 in the agenda. These representations annexure D, E, and F.
So for the petitioner submitting that
2 weeks, your lordship, my
it has fixed a meeting to be scheduled to be held on 8/4/2022, wherein his matter is listed for discussion. Praise for a week's accommodation.
20th, your lordship, may have it. 20th, my
Yes.
lord.
Next.
And at serial number 24, list number 2, I am appear for petitioner, my lord. 1 week
Yes.
time may be granted, my lord.
Of the petitioner, a week's time has spread is granted. Yes. Memos.
Notification was issued, and when notification it was not in that has been challenged.
Full. Yes.
Educational institution. The earlier trustee, the trustee over there, they are no more. It was listed for orders. Asking.
Mentioning.
It's true, my lord.
Yes.
Serial number 34, my lord.
Yes.
I am the respondent counsel.
Yes.
I will also inform the petitioner. I need a week's
My lords,
accommodation.
I appear for the petitioner in this matter, my lords. I have no
Yes.
objections, my lords. However, the interim order may be extended, my lords.
Both I presented the request of the learned counsel for the petitioner. A week's time has spread is granted. Yes.
My lords, interim order, my lords.
Make the mention the matter reaches. Yes. 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 Serial number? For the petitioner. The next time has spread is granted. Yes.
List to serial number 11, my lord.
Yes.
Sorry, my lord, I moved the matter without knowing that there is an office objection.
Yes.
I comply with the office objection, well, maybe called next week.
I appear for the respondent in this case, my lord. I appear for the respondent in this case, my lord.
Counsel from both sides present. Learned counsel.
My lord, interim order may be extended, my lord.
Place for a week's accommodation. The time has spread is granted as finally. Yes.
Interim order may be extended.
Take the mention the matter reaches. We will consider it. Yes. All the matters.
Ravindran P.
2 weeks time is granted to comply with subjection. A week's time has spread is granted to complete the office subjection.
Srinivas Koda, seal number 2.
My lord, I appear for the petitioner. 2 weeks time may be granted to comply of his objection.
Yes.
3.
2 weeks.
OPPM. 5. Syed Akbar Pasha.
1 week.
Ravindran P.
1 week.
Seal number 7.
The matter could not be proceeded.
Okay.
Same order.
Case number 2. Seal number 1, VV Kunjal. VV Kunjal.
On the petition, this matter, I have issued a notice for retirement, my lord, but 2 weeks time, let the acknowledgement as valid, my lord, because my client is in UK, the GP holder died. They are not given further instructions. I want to file a memo for retirement, my lord. In fact, today morning I sent an email also, that acknowledgement is filed at the office tomorrow. Finally, 2 weeks may be given, my lord. In the middle, let the
Sufficient time has already been granted, Mr. Counsel. Last year in September itself, for the very same submission, the time was granted to you.
thereafter he was not available. So that's why.
That is party's risk. What learned counsel can do. Yes, the learned counsel for the petitioner appearing to video conference. Since the petitioner is in UK and is general for of attorney, he prays for some more time. Not any perusal of the order sheet would go to show that for the very same purpose, as long back as on 15/9/2021, this court had granted time to him, despite which neither the office objections are complied with nor the memo of retirement has been filed. As such, the petition has dismissed for non-compliance of office objection. Yes.
Seal number 2, CBA Sachin.
Petitioner. 74-year-old petitioner. Also, each time.
At the request of the learned counsel for the petitioner who submits that the petitioner is not keeping good health, as finally a week's time has produced grant.
Number 3. Rajaram S. Kuratu, Ashok V. Ratri.
Unappear in this matter, either physically or through the phone. Final opportunity, a week's time is granted for the amendment and to make a submission regarding the maintainability of the petition in the absence of respondent number 1. Yes.
Haridasan. Seal number 4.
Appear for the petition. Reasons of force. The emergent notice was ordered on a 2 of 2017, 23/2022. Till date, petitioner has not taken appropriate steps to ensure the service of emergent notice upon the proposed respondent. Needless to say that the very purpose of issuance of emergent notice is to see that notice on the application is required to be served upon the party emergently. In spite of the same, since the petitioner is not evincing interest in ensuring the service of notice upon the respondent and has not prepared the process and furnished copies in the registry. A2 of 2017 stands dismissed for non-prosecution.
Sidhamalappa PM.
Left the particulars of the respondent cases, respondent please one more week time to application.
The counsel for the petitioner typically present and place for some more time. However, even according to the petitioner, since the sole respondent is dead on 28/7/2020, the petition abated. Yes.
Number 6, MD.
Counsel for the petitioner present the list. Delayed furnishing of PF is condoned with Registry to proceed further in the matter.
Number 7. Ready?
For petitioner, in spite of granting sufficient opportunity.
My lord, serial number 11, my lord.
Just to ensure this. 9 and 10. Hence, the petition as against respondent number 9 and 10 stands dismissed for not taking steps. Yes.
Serial number 11, my lord.
Number 8, Annaya CV. R3.
None appear in the matter. But of granting sufficient time since the petitioner has not carried out the amendment of cost title. Out of rupees 500 is imposed upon the petitioner. Cost is payable by the petitioner within 3 days. The legal services 4 and 5, a complaints memo along with receipt in the registry within the set period to that effect. Registry to carry out the amendment. Yes.
9, Vinod Reddy. 9, Vinod Reddy V. For the petitioner.
9, my lord. I appear for respond 1 and 2, my lord. On the last date of hearing, my lord, I filed memo, my lord, reporting death of respond 1 and 2, my lord. The petitioner is supposed to take steps, my lord. (25/3/2022).
None appear for petitioner. Respondent number 1 and 2 alone present. Petitioner, in spite of getting the notice of death of the respondent number 1 and 2 on 1/5/2021 and 5/2/2020 respectively, since have not taken steps to bring their legal representatives on record. The petition as against respondent number 1 and 2 stands abated. Yes.
10, Ajay J.
I appear for the petitioner, my lords. I will take steps, my lords, in 2 days. In the meanwhile, my lords,
I take notice for the deceased respondent, LRs of the deceased respondent 1 to 1, my lord.
The court on 17/1/2022 has ordered for issuance of notice on A 1, 2, and 3 of 2021 to the proposed legal representatives of This is a respondent number 1. The counsel for the petitioner is appearing through video conference. The counsel who is taking notice for
Joyce, my lord. Rakshit Joyce. Rakshit Joyce, my lord.
Counsel Sri Rakshit Joyce, who is also appearing through video conference, takes notice for proposed legal representatives of decision respondent number 1 on IAS 1, 2, 3, and 4, and prays for 10 days accommodation to file wakalat as well objections, if any, to those IAS.
Please.
10 days time as prayed is granted. Yes.
They may be directed to serve it on me, man.
I'll serve a copy on him today itself.
Much over.
You have to file wakalat. He has already been served. The question of permitting you doesn't arise. The petitioner to furnish copies of IAS 1 to 4 to the said learned counsel Sir Rakshit Joyce within 2 days from today.
I'll serve it today itself. I'm grateful.
Number 12, Parvati or Nair? 12.
In this case, appear for the petitioner, my lord.
Any more submission?
Lord, the interim order may be extended in this case, my lord. Respondent has not served the copy on me. He may be dead.
Whom you appear for?
For petitioner, my lord.
Whom you appear for? The counsel is physically present appearing for petitioner in this matter.
Serial number 11, my lord.
We do not know. You have to ascertain it. You have to hear it clearly. We are not on serial number 11.
Sorry, my lord. Sorry. Apologies.
Serial number 11 ಏನಾಗಿದೆ ರೀ? ಏನಾಗಿದೆ ಅದ್ರದ್ದು? ಹೌದ್ರಿ, ಅದರಲ್ಲಿ ಇಂಟ್ರಿ ಮಾಡ್ರಿ ಇದೆ ಇಲ್ವೇ? ಅದನ್ನ ನಾವು ಮ್ಯಾಟರ್ ಕರೆದಾಗ ಹೇಳ್ರಿ ಅಂತ ಹೇಳಿಲ್ವೇ? ನೀವು ಒಮ್ಮೆ ಕೊಡ್ಬೇಕಲ್ವೇ ನನಗೆ ಅದನ್ನ? ಅವ್ರು ಹೋಲ್ ಡೇ ಕಾಯ್ಬೇಕಾ ವಕೀಲರು? ಕೊಡಿ ಅದನ್ನ. ನೀವು ನಿಮ್ಮ ಶಾಲೆಯಲ್ಲಿ ಕೆಲಸ ಮಾಡಿ ವಕೀಲರಿಗೆ ತೊಂದರೆ ಮಾಡಬಾರ್ದು.
Number 11.
In this case, appear for petitioner, my lord.
ಲೇಟೆಸ್ಟ್ ಶೀಟ್ ಎಲ್ಲಿದೆ? ಅದಲ್ವಾ ಇದರದ್ದು? ಎಂಟ್ರಿ ಮಾಡೋದು ಯಾವಾಗಿದೆ ರೀ? ಇದ್ರಲ್ಲಿ ಇಲ್ವಲ್ರಿ?
Lord, not to precipitate till the next date of hearing, and it has been continuing, my lord. 6/9/2000. So 27/9.
ಆರ್ಡರ್ ಇಲ್ಲ ಇಲ್ಲಿ.
29/7/2019 it's there, my lord.
ಯಾವತ್ತು?
29/7/2019, my lord.
It is seen from the order sheet that on 29/7/2019, this court had directed to list the matter after 2 weeks. But the registry has not listed the matter for nearly 3 years. The learned registrar judicial to issue memos to the concerned officials in that regard and seek their explanation and submit his written submission. In the matter. Is the matter in the next week. The interim direction granted on 29/7/2019 is extended by a week from
Serial number 12, Parvati Nair, 12. The only opposition with regard to complaint supplement is that I went to outside and missed out to mention respondent number.
any other submission you have in this matter to be made.
Can I make a submission?
Yes, please.
R1 and R2, I have filed my wakalat with the registry today. But I wish to bring it to Jyoti's
Yes.
report.
Learned counsel for the petitioner is physically present. Counsel. So and so is also physically present and submits that he has filed wakalat for respondent number 1 and 2 in the registry today. The counsel for the petitioner is for a week's accommodation to complete the office subsection raised on the alleged complaints affidavit. Finally, a week's time as spread is granted. Despite the court particularly asking the learned counsel for the petitioner as to whether the petitioner has got any more submission to be made in this matter, the learned counsel for the petitioner submits none. In view of the same, for not taking the steps to ensure the emergent notice upon respondent number 3, the petition as against respondent number 3 stands dismissed for not taking steps. Yes.
Rajshekar S. Serial number 13.
They have filed wakalat for 8. Learned counsel for the petitioner and learned counsel for respondent number 2 are physically present. The counsel for respondent number 2 submits that he has filed wakalat for respondent number 8 also in the registry today. Registry to verify the same and proceed further in the matter. Yes.
Whether it is possible to deviate or the alternate.
It's from this side, they have brought it to the middle. No, they have no remedy. You have to go to the opposite building. ಹಾಗಾಗಿ ಶಿಫ್ಟ್ ಮಾಡಿರ್ತಾರೆ. ಯಾಕ್ರಿ ಹಾಗೆ ಮಾಡ್ತೀರಿ? ಅವ್ರು ಹೇಳ್ತಿದ್ದಾರೆ ಒಳ್ಳೆಯವರು ಶಿವಾಲಯ ಮಾಡುವರು, ನಾನೇನು ಮಾಡಿಲ್ಲ ಬಿಡುವನಿಗೆ.
Some sort of eight statements, even that's in that report also.
Certain matter. Yes, list the matter on 12. 12-2. Yes. 12-4. Yes.
Ragupati TN 14. Seven.
Because query is not present, can you wait till Monday? Can anyone use an amicus query? Learned counsel for the petitioner is physically present. Learned amicus query for respondent number 1 to 7 not present. Due to the non-appearance of learned amicus query, matter could not be proceeded today. Is the matter on 11/4? Yes.
A 15.
Here for the respondent. Sorry.
ಇದನ್ ಕೇಸ್ ಕರೆಕ್ಟ್ ನೆಕ್ಸ್ಟ್ ತೆಗೆದಿಡಬಹುದಲ್ವ ಐಎಗಳನ್ನ ನೋಡಿ ಅಡಿಷನಲ್ ಕೋರ್ಟ್ ಸೆಕ್ರೆಟರಿ ಯಾಕೆ ಇರ್ತಾರೆ? ಹೇಳಿದ್ರೆ ನಿಮಗೆ ಸಂಬಂಧ ಇಲ್ಲ ಅನ್ನೋ ಹಾಗೆ ಇರ್ತೀರಿ. ಇನ್ಆಕ್ಟಿವ್ ಎಲಿಮೆಂಟ್ಸ್ ಅಂತ ಇರ್ತದೆ ಕೆಲವೊಂದು. ಇನ್ಆಕ್ಟಿವ್ ಕಾಂಪೌಂಡ್ಸ್, ಇನ್ಆಕ್ಟಿವ್ ಎಲಿಮೆಂಟ್ಸ್ ಕೆಮಿಸ್ಟ್ರಿಯಲ್ಲಿ. One bar 22 ಕೊಡಿ. These are the original copy of the IA. ಒರಿಜಿನಲ್ ಕೊಟ್ಟಿದ್ದೀರಿ ಅಲ್ವಾ? ಮತ್ತೆ ಸರಿಯಾಗಿ What is your submission on the IEF for recalling? Take the counsel for the petitioner, whom you appear for.
Content. P-A-2-P.
The senior counsel for respondent number 3A2 C, H and J. There are HCGP for R1 and R2. R2. And your counsel for respondent number R3D2I are physically present. Heard the submission of the counsel, HCGP on. Okay, 1/22. Then Section 151 CPC seeking to recall the order dated 24/3/2022, imposing a cost of ₹10,000 on the office of Central Bengaluru. Have you filed the records now? You cannot give it in the court by hand now. There is the application. There is the application. Once Puttaraja Gowda, who is said to be the Tahsildar of Channagiri Taluk, Danagiri district, has sworn to an affidavit stating that they were under an impression that the record called for has already been submitted to the office of the Advocate General. However, of late they came to know that the record sent to the office of the AG was different than the one sought for by them. As such, with mixing up of the record in their office, there was delay. Admittedly, till now, the record called for as long back as on 11/11/2019 has not been filed in the registry. Even though the Tahsildar has deposed in a sworn affidavit, but admittedly he was not the Tahsildar from the year 2019 till date. As such, is not aware as to what has transpired at the earliest point of time when the record was called back as long back as on 11/11/2019. Even if his statement is taken on record, still, in response to calling for records, his office had already sent some records to the office of the Advocate General. In such a situation, it was for the office of the Advocate General to verify the records, and if it is noticed that those records were not the one that was called for, then to return those records with a direction to submit the proper record that was called for by the court at the earliest. This attempt, the office of the Advocate General has not done till 4/3/2022, when this court made a serious observation regarding the heterogeneous on the part of the office of the Advocate General. Since the same was continued on the subsequent dates of hearing also, the court imposed a fine of ₹10,000 upon the office of the Advocate General under a reasoned order, wherein it has also noticed that the present writ petition is stalled only for the requirement of the records that was called for on 11/11/2019. The writ petition is of the year 1993. As such, it is 28 years old matter. Since the contribution of the office of the Advocate General was significant is also significant in causing the delay, the court was constrained to impose a cost. In the light of the above, and also considering the fact, even at the present moment also, the file called for has not been filed in the registry, with person not showing any leniency, could not arise according to IA 1/22 stands rejected. However, with an observation that in case the Office of the Advocate General does not file the necessary records in the registry within 3 days from today, the court may proceed to pass more stringent observation against the Office of the Advocate General. But what about the IAs? Let him file the record, then they will proceed. Finish the matter on 18. 4. Yes.
For the petitioner, my lord, I made this application.
Respondent, there is one issue, my lord, with respect to the LR application. What has happened, my lord, in the LR application, all LRs are not implemented. Only the children of the plaintiff are implemented. The wife of the plaintiff has not been implemented in the LR application.
So you appear for LRs.
I appear for the LRs, my lord. LRs of the plaintiff in the suit and LRs of the respondent in the writ petition. The writ petition, my lord. Ibrahim Abdullah Sheikh is the respondent, and he was represented by his guardian Nur Jahan Sheikh. After his death, my lord, the children as well as the wife had to be implemented as parties. They have not implemented the children as well as the wife.
No, Mr. Counsel, when you say that they have not implemented so and so, is it not that the very purpose of issuing notice to the alleged legal representatives is to ascertain that whether they are the only legal representatives or are there any persons more?
Yes. What they say at paragraph.
Was it not your obligation and the duty towards the court to bring?
Yes.
The alleged discrepancy in the application?
Yes. At page
Without
4.
doing that, how can you accuse the other stating that they have not brought the other legal representative on record instead of telling that you should have brought to the notice of the court at the earliest that there are few more legal representatives who are required to be brought on record?
Can I clarify? Can I clarify?
Yes, please.
Yes, at page 4 of their LR application, they themselves say that the wife, they are aware that wife is the legal representative. At para 2, they themselves say that wife is not necessary because she is already a party, which is not the
Then you did not oppose the application. Did you file objection to the application?
No, my lord. What has happened is, here the technicality is this. Can the guardian who represents the plaintiff, can the guardian be treated as a party after the plaintiff expires? That cannot be so, because the guardian dies with the plaintiff. I mean, the guardian collapses with the plaintiff.
That is another phase. We are not on that point. We come to that. That is the second stage. But initially, when you say that there are two more legal representatives,
yes,
and the legal representatives upon whom the notice was served before allowing the application,
yes,
they primarily owe a duty to the court to bring the complete details to the notice of the court.
That is what.
Stating that apart from us, or in addition to that, there are few more legal representatives. They are also required to be made as parties.
Correct, but
you did not do that. You did not file any objection.
Even if I don't file the objection, Lord, they themselves say that she is not a necessary party. That is, kindly see para 2.
You could have opposed that, sir.
If they exclude me, if they by themselves want to exclude me.
My simple question is, did you file your objections to the LR applications?
We filed the objection to the LR application, but no notice. No, we have not filed the objection to the LR application.
That is it. That is it. You have not filed.
That is for the 4 persons, the children who are represented. There is no notice served to the wife at all. To the wife, no notice is served.
Sir, is it not that the legal representatives who have come on record,
yes,
they were aware of the existence of wife of the deceased person?
It is not necessary.
They are the daughters and son of the deceased person.
Allah, they are saying that
ನಮ್ಮ ಒಬ್ಬನ ಹೆಂಡತಿ ಇನ್ನೂ ಬದುಕಿದ್ದಾರೆ, ಅವರು ಇದ್ರಲ್ಲಿ ಬರ್ಬೇಕು ಅನ್ನೋದು ಅವರಿಗೆ ಗೊತ್ತಿತ್ತು ತಾನೆ.
ಪ್ಲೇಂಟಿಫ್ಗೂ ರಿಟ್ ಪಿಟಿಷನರ್ಗೂ ಗೊತ್ತಿತ್ತು. ರಿಟ್ ಪಿಟಿಷನರ್ ಹೇಳೋದು ಏನಂತಂದ್ರೆ ಶಿ ಇಸ್ ಆಲ್ರೆಡಿ ಅ ಪಾರ್ಟಿ ಅಂತ.
ನೀವು ಮತ್ತು ಅಲ್ಲಿಯೇ ಹೋಗ್ತಾ ಇದ್ದೀರಿ ವಕೀಲ್ರೆ, ಮತ್ತು ಅಲ್ಲಿಯೇ ಹೋಗ್ತಾ ಇದ್ದೀರಿ. ಅವರು ಗೊತ್ತಿದ್ದೋ ಗೊತ್ತಿಲ್ಲದೆಯೋ ಬೇಕಂತಲೇ ಹೇಳಲಿಲ್ಲ. Has that prevented you from taking effective steps?
Assuming, my lord, I have
even now also you can ensure that a necessary application is filed in the court.
Very well.
What I am trying to endure upon is,
please.
ಪ್ರತಿ ಸರ್ತಿ ವಕೀಲರು ಅಂತ ನಿಂತು ಕೂಡಲೇ ಮೊದಲನೇದಾಗಿ ಕೋರ್ಟ್ ಬರಲು ಮಾಡಿ ತೋರಿಸೋದು, ಕೋರ್ಟ್ ಡಿಡ್ ನಾಟ್ ಅಪ್ಲೈ ದಿಸ್ ಮೆನ್, ದಿಸ್ ಡಿಡ್ ನಾಟ್ ಸಿ ಇಟ್ ಪರ್ವರ್ಸ್ ಅಂತ ಕೋರ್ಟ್ ಮೇಲೆ ಅಲಿಗೇಷನ್ ಮಾಡೋದು, ವಕೀಲರ ಮೇಲೆ ಅಲಿಗೇಷನ್ ಮಾಡೋದು. ಅದನ್ನ ಕಡಿಮೆ ಮಾಡಿ.
ಅಲ್ಲ, ಕೋರ್ಟ್
ಏನ್ ಮಾಡ್ಬೇಕಿತ್ತು ನೀವು ಮಾಡಿದ್ದೀರಾ ಅದನ್ನ ಫಸ್ಟ್ ನೋಡಿ.
ಅಲ್ಲ, ಕೋರ್ಟ್
ಯಾವ ರಗಳೆಯೂ ಇರಲ್ಲ, ಬೇಗ 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 ಕೇಸ್ ಮುಗೀತದೆ.
ಅಲ್ಲಿ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಕೇಸ್ ಮುಗಿತಾ ಇಲ್ಲ ಅನ್ನೋದು ನಮ್ ತೊಂದ್ರೆ ಇಲ್ಲ. ಯಾಕೆ ಅಂತಂದ್ರೆ ಎರಡ್ ಕಡೆನೂ ಕೋಆಪರೇಟ್ ಮಾಡಿದ್ರೆ ಕೋರ್ಟ್ ಕೇಸ್ ಮುಗಿಯುತ್ತೆ. ಎರಡ್ ಕಡೆನೂ ಕೋಆಪರೇಷನ್ ಇಲ್ಲದ್ರೆ ಕೋರ್ಟ್ ಕೇಸ್ ಮುಗಿಯಲ್ಲ. ಈಗ ಇಲ್ಲೇನಾಗಿದೆ, ಈ ಕೇಸ್ ನಲ್ಲಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ನಲ್ಲಿ 6 ವರ್ಷ ಕೇಸ್ ನಡೆದ್ಬಿಟ್ಟು ಈಗ ರಿಟ್ ಪಿಟಿಷನ್ 2015 ಅಲ್ಲಿ ಹಾಕ್ಬಿಟ್ಟು ಅಲ್ಲಿ ಜಜ್ಮೆಂಟ್ ಆಗೋ ಸ್ಟೇಜ್ ಬಂದಾಗ ಈಗ IFR ಸ್ಟೇ ಪ್ರೆಸ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ ಆಫ್ಟರ್ 6 years.
Exactly, my lord.
Is it sustainable? Is it sustainable? Number one. Second thing, Lord, in the meantime, they do not make a complete LR application. And that LR application, if time is given, I will notify that LR application of the wife also has to be made a, she has to be made a party.
ಹೌದು, ಅದಕ್ಕೆ ನೀವು ಏನ್ ಮಾಡ್ಬೇಕು, ಅವ್ರು ಮಾಡ್ಲಿಲ್ಲ ಅಂದ್ರೆ ನಿಮ್ಗೆ ಲೀಗಲಿ ಏನ್ ಮಾಡ್ಬೇಕು ಅದನ್ನ ನೀವು ಮಾಡಬಹುದಿತ್ತಲ್ವೇ? ಈಗ ನೀವು ಅದನ್ನು ಮಾಡದೆ, ಆರ್ ಯು ನಾಟ್ ಕಾಂಟ್ರಿಬ್ಯೂಟಿಂಗ್ ಫಾರ್ ಫರ್ದರ್ ಡಿಲೇ ಆಫ್ ದ ಮ್ಯಾಟರ್?
ಈಗ ಅವ್ರು ಎಲ್ಲ
ನಾನು ಹೇಳ್ತಿರೋದು ಅಷ್ಟೇ, ಕೇವಲ ಎದುರುಗಡೆ ಮೇಲೆ ಅಕ್ಯುಸೇಷನ್ ಮಾಡೋದ್ರ ಬದಲು ನಾನು ಏನ್ ಮಾಡಬಹುದು ಇದರಲ್ಲಿ ಆಸ್ ಎ ಕೋರ್ಟ್, ಆಸ್ ಎನ್ ಅಡ್ವೊಕೇಟ್ ಫಾರ್ ಒನ್ ಆಫ್ ದಿ ಪಾರ್ಟಿ. ಮುಂದೋಗಿ ಬಿಡ್ತದೆ, ಎಷ್ಟೋ ಟೆಕ್ನಿಕಾಲಿಟೀಸ್, ಎಷ್ಟೋ ಹರ್ಡಲ್ಸ್ ಬಿಡ್ತದೆ. ಈಗ ಇವತ್ತು ನೀವು ಏನ್ ಹೇಳ್ತಾ ಇದ್ದೀರಿ, ಅದಕ್ಕೆ ನಿಮ್ಮ ಪ್ರಕಾರ ಇನ್ನು ಯಾರ್ಯಾರನ್ನ ಲೀಗಲ್ ರೆಪ್ರೆಸೆಂಟೇಟಿವ್ ಮಾಡಬೇಕು, ಅವರಿಂದ ಒಂದು ನೆಸೆಸರಿ ಅಪ್ಲಿಕೇಶನ್ ಅನ್ನು ಹಾಕಿ ಅದರ್ ಸೈಡ್ ಸರ್ವ್ ಮಾಡಿ ಬಿಟ್ಟಿದ್ರೆ ಅಡ್ವಾನ್ಸ್ ಆಗಿ ಇವತ್ತು ಕೇಸ್ ಬರ್ಲಿಕ್ಕೆ ಮುಂಚೆಯೇ ಮುಗ್ದೋಗಿ ಬಿಡ್ತಿತ್ತಾ ಇಶ್ಯೂ?
ಅಲ್ಲ,
can I intervene?
On record.
Can I intervene, my lord?
Their claim
Please.
is she is already on record.
My submission is this, my lord. So far as LR application is, my lord, that is already allowed by this honorable court. Now, my lord, today, my lord, IA 1 of 22 to stay the further proceedings, for which, my lord, this honorable court granted 1 week's time to the other side. They don't file their statement of objections. Whereas before the trial court, my lord, now today matter is posted for final hearing. It was there on 28th of last month that made me to file this application to stay further proceedings, my lord.
For 6 years, so 2014 is the suit. From 2014 till 2022, for 8 long years, they are aware that the suit is pending. They filed their written statement. They have not submitted themselves to evidence. For about 3 years continuously, the plaintiff is attending the court in order to render her evidence in Sakleshpur, going from Bangalore and rendering evidence. After evidence is complete and matter is posted for arguments, suddenly this writ petition gives, they try to give life to this writ petition.
No.
This only purpose is
2015.
What the main issue in the suit is, my lord, by fraud, they have executed a sale deed. A nephew has taken the sale deed from his uncle. By keeping away the
and learned counsel for respondent number 1 A to D are appearing through video conference. Learned counsel for R1 A to D submits that petitioners have not brought on record all the legal representatives of the deceased respondent number 1. Learned counsel for the petitioner submits that the respondent, without taking any such contention earlier, now only in order to delay the disposal of IA 1/22, have come up with a contention of alleged that out of some of the legal representative of the deceased respondent number 1. He further submits that the matter in the trial court is slated. ಯಾವತ್ತಿಗಿದೆ ಅಂದ್ರೆ ಅದು ಒರಿಜಿನಲ್ ಸೂಟು
ಇವತ್ತಿಗೆ ಫೈಲ್ ಫಾರ್ ಫೈನಲ್ ಆರ್ಗ್ಯುಮೆಂಟ್
slated for today for final hearing of the argument in the trial court. Next line. Admittedly, notices were sent on the legal representative applications, sent on the application seeking to bring legal representative of this is the respondent number 1 on the proposed respondents number 1A to 1B, who are said to be the daughters and son of this is a respondent number 1. Now the learned counsel for those LRs of R1 submits that the wife of this is a respondent number 1 is also alive, and the same was known to the petitioner since the petitioner themselves have mentioned so in the affidavit. In the above circumstance, nothing had prevented for the alleged.
They say it is not necessary.
1D to file the statement of objection to the LR applications, bringing the said fact to the notice of the court, which they did not do. Even today also, neither the alleged wife of this is respondent number 1 nor respondent number 1A to 1D have come up with any such application bringing the existence of wife of respondent number 1 to the notice of the court and are impleading in the matter. Simultaneously, the respondents also have not filed the statement of objection if any to IA 1/22. In the light of the above and also considering the urgency shown by the petitioner for the interim direction,
Lord, can I make a request?
the respondents
Can I make a request?
of objection to IA 1/22. Both parties are directed not to precipitate the matter further in OS 4/2024.
Can the trial go on, Lord?
15.
Let the trial go on.
Let the date of hearing of this read petition.
Can I make a request? At least let the trial go on.
1, 2. Yes.
Lord, can I make a request? At least let the trial go on. Let the
No,
court.
it is for further arguments, sir. Trial alli. Final argument. Oh, yes.
They are filing application for evidence.
17 years,
Lord, can I make a request? Can I make a
Please.
Lord, what I feel is, of course, your lordships are entitled to take a view. What I feel is, my lord, ultimately, if a party by himself says that it is not necessary, how could I be blamed, my lord?
You are the chairman of the Advocate Association now.
Yes.
Hold a seminar there. Invite we lordships, including me.
Yes.
We can deliver a lecture on that concept.
But the last thing I would do is invite your lordship to give an opinion on your lordship's judgment.
Yes,
that may not be right, my lord, because your lordship will have to overrule your own judgment while giving opinions.
Yes.
17 years suspended for disease petition. Yes,
Please, my lord, I appeal for the petitioner. I may be pardoned, my lord. Last time your lordship asked me about the correct provision of bringing the LR. My lord, I have mentioned order 1 and rule 10. After examination, it is order 22, rule 2 and 3. I may be pardoned, my lord.
Who appears for respondent? The counsel for the petitioner is appearing through video conference. The counsel responded neither present physically nor through video conference. No reasons are forthcoming for the appearance of learned counsel for the respondent. In spite of granting several insufficient opportunities, the respondents have not filed their. Respondent has not filed his statement of objections in IAS 1, 2, and 3 of 2022. Okay. Heard the learned counsel for the petitioner on IA 1, 2, and 3 of 2022. IA 1 is filed under Section 5 of the Rejection Act, seeking condonation of a delay of 980 days in filing. IA 2 and 3 of 2022. IA 2 of 2022. Section 151 of CPC, seeking setting aside of the abatement in bringing the legal representatives of the petitioner on record. The 3/22 is filed under Art 10 Rule 1 and 2, read with Section 151 of CPC. Seeking to bring the applicants therein on record as the legal representatives of alleged deceased petition. Though IA 2 and 3 have not been filed in the proper provision of law, however, considering the prayer made in the application, I am of the view that imposing some cost, those two applications can be treated as the one 22 rule filed under the appropriate provision of law. Order 22 of CPC. Next line, the reason shown in the IA 1/22 for alleged delay in filing the application that due to corona pandemic, COVID-19, the strained financial condition of the petitioner, the application could not be filed in time, is not denied or disputed from the respondent. As such, the reason since being, as such, the cause since appears to be sufficient cause for condonation of delay, IA 1/22. It is allowed a delay of 980 days in filing. IA 2 and 3 of 2022 stands condoned. The suit is one for specific performance instituted by the present petitioner against the present respondent. As such, even by the death of the present petitioner, who was the plaintiff in the original suit, right to sue survives for the alleged legal representatives of the deceased petitioner. As such, IA 2 and 3 of 2022 are also allowed, however, at a cost of ₹500 payable by the applicants therein to the Legal Services Committee of this court within a week from today and filing the complaints memo along with receipt in the registry within the said time. Subject to payment of the cost, the applicants in IA 3 of 2022 are permitted to come on record as petition number 1A-1E, since the death of the sole petitioner is corroborated by the death certificate produced along with the application, which shows that the petitioner is died on 31/1/2019. Petitioners 1A-1E to carry out the necessary amendment to the cost title of the petition and to file amended memorandum of petition in the registry. 2 weeks from today, however, duly serving copies to the respondent. Yes.
18 G के बाद
Praying for respondent number 5, Your Lordship.
Please.
relevant to our court.
Whom you appear for? ಮೈಕ್ರೋಫೋನ್ ಇದೆಲ್ಲ ಯೂಸ್ ಮಾಡ್ರಿ. ಯಾಕೆ ದೂರ ನಿಲ್ತೀರಿ? ಅದು ಇಟ್ಟಿದ್ದೆ ನಿಮಗಲ್ವೇ? ಇನ್ನು ಈಚೆ ಬನ್ನಿ. ಹಾ, ಬನ್ನಿ ಈಚೆ. ಅಲಗಾಡ್ದೆ ನಿಲ್ಲಿ. ಯಾಕೆ? Statement of objection for what? IA ಯಾವ್ದಕ್ಕೆ ಹಾಕಿದ್ದಾರೆ ಅವರು? ಅದು ಮುಂಚೆ ಯಾಕೆ ನೀವು ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕ್ಲಿಲ್ಲ?
Then on the previous day submitted, I was 2 days time. Then I was trying to have it. In on the fifth respondent also not signed any of it. Utilization also. But I need the sixth respondent is taking that.
Sixth respondent, according to sixth respondent, who submitted no objection? Fifth respondent. Now her brother is seeking time.
Yes.
Your Lordship, if I'm appearing for respondent number 5, if he's saying that respondent 6 is my brother, let him put it in an affidavit, Your Lordship, to say that he is my brother. I am nowhere concerned to his family, Your Lordship. Coincidentally, the petition, the respondent 6 sister name is also Savita and my name is also Savita. Misunderstanding that one, they're taking the advantage of that. Let them file an affidavit saying that I am taking time, I have taken last name brother.
You have no objection for allowing IA 1/21, right?
Your Lordship, I have to file the objection also. There was some inconvenience, Your Lordship, to file the objections, Your Lordship. The next date, by the next date, I will be filing them.
Subsequent change in the stand, I do not think that it is any specific property like that. Once you make it, give a stand, you take time on that. We have got an objection, we can file it because it's third. As long as it is the month of February 2025. 1 year back. If they dispute the identity of the petitioner, I find that explanation.
ಅದು ಮಾಡುವ ಈಗ ಐಡೆಂಟಿಟಿಗೆ ಅದಕ್ಕೆ ಅಪ್ರೋಪ್ರಿಯೇಟ್ ಸ್ಟೇಜ್ ಅಲ್ಲಿ ನೋಡುವ. ಈಗ ಅವ್ರು ಹೇಳಿದ್ರು ಅಂತ ನೀವು
inquiry report is already placed on the report. That is not disputed, there is no scope for protection because that is made compliant with the direction to the honorable report. Once that is seen, whether I am true or other side is true, it is established. This document and keeping produce is only an agreement on a strong paper post dated. So only two documents.
ಆಗ್ಲಿ 3 ದಿವಸ ಕೊಡೋಣ ಟೈಮು ಆಸ್ ಅ ಲಾಸ್ಟ್ ಚಾನ್ಸ್ ಅಂತ learned senior counsel for the petition. Learned counsel for respondent number 6 are physically present. Learned counsel for respondent number 5 is appearing through video conference. Learned counsel for respondent number 6, citing the reason of some medical inconvenience in house of his senior, prays for 3 days accommodation to file with the objection to IA 1/21. At final opportunity, the time as prayed is granted. Reach this matter on 12/2, 12/4, April 12/4, 2020.
We are for respondent 1 to 3 minutes.
Four 36, you have to file wakalat, right? Learned counsel for the petitioner, physically present. Learned counsel for respondent number 4 to 6, who is also physically present. Prays for 3 weeks accommodation to file his wakalat for respondent number 4 to 6. Impleading new hakidda.
One submission. I had filed 2 applications. IA number 2 and IA number 3.
Today 2/20. Really?
IA number 2 and IA number 3. IA number 2 is the immediate application. IA number 3 is the amendment application. And the last date of hearing, this matter was came up. Copies were served on the other side. And I responded number 1 to 3, where amendment application, they have also filed objections. Unfortunately, when the orders is pronounced, there was some confusion in taking the orders as it is pronounced, and they have said IA number 3 does not survive. So if the objections filed, and I checked in the file, objections are filed on 26th of February, and it came on 28th. The other side counsel respondent number 1 to 3 appeared online and made a submission. I have filed the objections. Your Lordship said objections raised on IA3 does not survive. Objection does not survive for consideration was the order pronounced. Unfortunately, the order sheet, the IA only does not survive, and it is written in what is transpired in the order sheet.
But
They have filed objections.
according to you, there is a error in transcription.
My lord, I appear, my lord, for respondent 1 to 3, my lord. IA number 1 that my learned friend is referring to, my lord, was an application for amendment. Due to non-clearance of office objections, your lordship had on the last occasion rejected that application. IA2, my lord, is for impleading that is listed today. I don't know what IA3 is, my lord. I don't have the benefit of a copy. My learned friend doesn't appear to have served it on me, my lord.
Madam, is confusing. What I say? IA number 1 is the dispensation application. That is being dispensed. IA number 2 is impleading application. IA number 3 is amendment application.
No, IA number 3 has stood returned for non-rectification of office objection, right?
Respondent number 1 to 3 have also filed objections to my amendment application, and it is on record on 26th February only. See that your lordship is directed because the office they already filed objections. Unfortunately, it is heard like the IA only does not survive for consideration. You may see objections filed by respondent number 1 to amendment application. It is
IA 3/21. No, with respect to IA 3/21, probably, no doubt exists as on date. It appears that as on that day as well as on today also, for the very simple reason, irrespective of the fact that whether the opponents in this said application have filed their objections to it, till the office has raised certain objection on the application itself. That application has stood a return. Once the application has stood return, application has stood return for non-rectification of the office objection.
Application is only to serve on the other side. There is no other error. Only to serve on the other side.
Sir, you are not granted time to comply office objection. The application has stood returned to you. You should have ensured it restoration on the file before proceeding further. ಭೂತಕಾಲ ತಮಗೆ ಹಿಂದಿರುಗಿಸಲ್ಪಟ್ಟಿದೆ. ಹಿಂದಿರುಗಿಸಲ್ಪಟ್ಟಿದೆ ಎಂಬುದನ್ನು ತಾವು ಮತ್ತೆ ಕಡತಕ್ಕೆ ವಾಪಸ್ ಪುನರ್ ಸೇರ್ಪಡೆ ಮಾಡಿಕೊಳ್ಳಬೇಕಾಗಿತ್ತು. ಪುನರ್ ಸೇರ್ಪಡೆ ಮಾಡಿಕೊಳ್ಳ ನಂತರವಷ್ಟೇ ಅದು ಮುಂದಿನ ವಿಚಾರಣೆಗೆ ಮುಂದಿನ ಹಂತಕ್ಕೆ ಅರ್ಹತೆ ಹೊಂದಿರುತ್ತದೆ. ಅದು ಆಗ್ಲಿಲ್ಲ. ಸ್ಟುಡ್ ರಿಟರ್ನ್ ಅಂತ ಆಗಿರೋದ್ರಿಂದ ಅವ್ರು ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕೋದು ಬಿಡದು ಅದು ಬ್ಯಾಕ್ ಗ್ರೌಂಡಿಗೆ ಹೋಗ್ತದೆ. ಹಾಗಾಗಿ ಟ್ರಾನ್ಸ್ಕ್ರಿಪ್ಷನ್ ಎರರ್ ಇಲ್ಲ. ದಿ ಆಫೀಸ್ ಇಟ್ಸೆಲ್ಫ್ ಹ್ಯಾಸ್ ನೋಟೆಡ್ ದಟ್ ಇಟ್ ಹ್ಯಾಸ್ ಆಲ್ರೆಡಿ ಸ್ಟುಡ್ ರಿಟರ್ನ್. ಆಫೀಸ್ನವ್ರು ಒಂದು ಮಿಸ್ಟೇಕ್ ಏನ್ ಮಾಡ್ತಾರೆ ಅಂತ ಹೇಳಿದ್ರೆ ಅಂತ ಸ್ಟುಡ್ ರಿಟರ್ನ್ ಅಂತ ಆಗಿರೋದನ್ನ ಕಾಸ್ ಎಕ್ಸ್ಟೆಂಟ್ ತೋರಿಸುವ ಅವಶ್ಯಕತೆ ಇಲ್ಲ. ಕಾಂಪ್ಲೇಂಟ್ಸ್ ಆಫ್ ಆಫೀಸ್ ಸಜೆಷನ್ಗೆ ಡ್ಯೂ ಇದ್ದದನ್ನ ತೋರಿಸ್ಬೇಕು. ಅವಾಗ ಇಲ್ಲಿ ನಾವು ಟೈಮ್ ಕೊಡಬಹುದು. ಇಫ್ ದ ರಿಜಿಸ್ಟ್ರಿ ಇಟ್ಸೆಲ್ಫ್ ರಿಟರ್ನ್ಸ್ ಇಟ್, ಅದು ಶೀಟ್ ನಲ್ಲಿ ಮೆನ್ಷನ್ ಮಾಡಬೇಕು ವಿತ್ ದ ಸಿಗ್ನೇಚರ್ ಆಫ್ ದ ರಿಜಿಸ್ಟ್ರಾರ್ ಜುಡಿಷಿಯಲ್ ಆಫ್ ದ ಡೆಪ್ಯೂಟಿ ರಿಜಿಸ್ಟ್ರಾರ್ ಆಸ್ ದ ಕೇಸ್ ಮೇ ಬಿ. ಅದ್ ಮಾಡ್ಲಿಲ್ಲ. ಹಾಗಾಗಿ ಕೋರ್ಟ್ ಮುಂದೆ IA 3/21 ಅನ್ನೋದು ಇರ್ಲಿಲ್ಲ. ಇಟ್ ಸ್ಟುಡ್ ರಿಟರ್ನ್ ಅನ್ನೋದನ್ನು ಮಾತ್ರ ಕೋರ್ಟ್ ತಗೊಂಡು ರಿಜಿಸ್ಟ್ರಿ ಹ್ಯಾಸ್ ನೋಟಿಸ್ಡ್ ದಟ್ IA 3/21 has already stood return. With that observation only the court proceeded further.
On that day, 28, that side also came on record on the video conferencing and said we have filed objections. With that, the only objection was there on the IA.
Sir, ಅದನ್ನ ನೀವು ಮೆನ್ಷನ್ ಮಾಡಬೇಕು, ಅದನ್ನ ಮಾಡಿಸ್ಬೇಕು, ಕೋರ್ಟ್ ಇನ್ನೊಂದು ಆರ್ಡರ್ ಮಾಡಿಸ್ಬೇಕು. ಅಂತದ್ ಏನು ಮಾಡದೆ ಹೋದ್ರೆ ಹೀಗೆ ಆಗ್ತದೆ. ಹಿಂದಿನ ಮ್ಯಾಟರ್ ನಲ್ಲಿ ನಿಮ್ಮ ಪ್ರೆಸಿಡೆಂಟ್ ಅಂತ ಹೇಳಿದ್ರು ನೋಡಿ, ಹಾಗೆ ಆಗ್ತದೆ. ಈಗ ನೀವು ನಿಮ್ಮಗಳ ಲೋಪಗಳನ್ನು ಹಾಗೆ ಇಟ್ಟು ಕೇವಲ ಬೆರಳನ್ನು ಎದುರುಗಡೆ ವಕೀಲರಿಗೆ ತೋರಿಸಲಿಕ್ಕೆ ಹೋದ್ರೆ ಹೀಗೆ ಆಗ್ತದೆ. ನಿಮ್ಮ ಎದುರುಗಡೆ ಹಾಜರಾಗುವ ವಕೀಲರು ನೀವು ತಿಳಿದಷ್ಟು ನಿರಾಸಕ್ತರು ಆಗಿರುವುದಿಲ್ಲ. ಬೇರೆ ಪದ ಇದೆ, ನಾನು ಉಪಯೋಗಿಸಲ್ಲ ಅಂತ ಭಾವಿಸ್ಬೇಡಿ. ಹೇಳಿ, ಈಗೇನ್ ಮಾಡ್ತೀರಿ ಹೇಳಿ. ಅದಕ್ಕೆ ನೀವೊಂದು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕ್ಬೇಕು. ಅಪ್ಲಿಕೇಶನ್ ಹಾಕ್ಬೇಕು ಟು ರಿಕಾಲ್ ದಿ ಆರ್ಡರ್ ಆಫ್ ಸ್ಟ್ಯಾಂಡಿಂಗ್ ರಿಟರ್ನ್. Registry has noted that it has stood return that has been confirmed in the order sheet. ಹೌದು, ಈಗ ಇವತ್ತಿಗೆ ಇರೋದು ಯಾವುದು? ಹಾ, ಅದ್ರ ಮೇಲೆ ನೋಟಿಸ್ ಆಗಿದೆಯಾ? ಸರ್ವ್ ಟು ಆಲ್. ಹಾ, ನೀವು ಆಲ್ರೆಡಿ ನೋಟಿಸ್ ತಗೊಂಡಿದ್ದೀರಿ ಅವರಿಗೆ. ಟೈಮು ಸಾಕಷ್ಟು ಇತ್ತಲ್ಲ ನಿಮ್ಗೆ. ನೀವು ಬರೀ ಬಿಲ್ ಏರ್ಸಿನೇ ಜನಗಳಿಗೆ ಶಾಕ್ ಕೊಡೋದು, ಉಳಿದಂತೆ ನಿಮ್ಮ ಕರೆಂಟ್ ಹರಿಯೋದೇ ಇಲ್ಲ. ಕೇಸ್ಗಳಲ್ಲೂ ಹರಿಯಲ್ಲ, ಕಂಬದಲ್ಲೂ ಹರಿಯಲ್ಲ ಅಲ್ವೇ? 1.5 ತಿಂಗಳ 2 ತಿಂಗಳ ಹತ್ತತ್ರ ಆಯ್ತು ನೀವು ನೋಟಿಸ್ ತಗೊಂಡು. ಕೌನ್ಸಿಲ್ ಶ್ರೀ ವಿ ದೇವರಾಜ್, H.V. ದೇವರಾಜ್. ಅಲ್ಲಿ ಬಂತಲ್ವಾ 4 to 6 ಅಂತ ಮೇಲೆ ಬಂದಿದೆ ಅಲ್ವಾ ಪ್ರೆಸ್ ಫಾರ್ ಎ ವೀಕ್ಸ್ ಟೈಮ್ ಅಂತ ಹಾಕಿ ಒಂದು ವಾರದೊಳಗೆ ಹಾಕಿ. ಎಸ್ ಲಿಸ್ಟ್ ದ ಮ್ಯಾಟರ್ ಇನ್ ದ ನೆಕ್ಸ್ಟ್ ವೀಕ್. ಅದಕ್ಕೆ ಡೇಟ್ ಇನ್ ನೆಸೆಸಿಟಿ ಎಲ್ಲಿದೆ ರೀ? ನೀವು ಇವತ್ತೇ ಹಾಕ್ರಿ. ಹಾ, ನೀವು ಮುಹೂರ್ತ ಇಟ್ಕೊಡಿ ಸ್ವಾಮಿ, ನಾವು ಹುಡುಗಿನ ಕರ್ಕೊಂಡ್ ಬರ್ತೀವಿ ಇಂದಂಗ ಆಯ್ತಿವಿ. ಮುಹೂರ್ತ ಯಾಕೆ ಬೇಕು? ನೀವು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕೋದಕ್ಕೆ ಇವತ್ತೇ
For objections also, the date will be.
list the matter on 13/4. Yes.
Number 20. Pradesh.
Yes, please. This is my application in the petition of this honorable court for consideration. Since I ascertained the fact that the property is still available for petition, I filed an IA-1 of 2019 before this honorable court, along with the writ petition, to seek for an alternate relief in addition to specific performance. That IA was not considered by this honorable court by passing the order, because it came for all.
Filed an IA. What provision?
I filed an IA under Article 227, Red Section 151 CBC.
For what?
To seek
IA
for
1/19 ಕೊಡ್ರಿ.
IA 1/2019.
Yes.
Now, please reports. An alternate relief in a suit for specific performance can be sought for before the honorable court at any given point in time. It's not gone by limitation also. In that regard, I would kindly request this honorable court to consider section 22 of the specific.
No, we will go to that aspect. Please. That is on the merit that probably, if at all, you succeed in this RP, that may arise at a later stage.
Please.
Yes.
So now this was the relief which I sought for before the honorable court in writ petition.
This honorable court, while considering the writ petition as well as this IA which was pending for consideration, failed to notice that this not being bound by limitation or time could be sought for by the plaintiff.
WT prayer copy previously disposed of. Yes.
This relief could be sought for by the plaintiff petitioner at any given point in time without passing an order on merits on this IA, just dismiss the IA in dismissing the writ petition. My lords, in that regard, the operating portion of the order which is impugned before this honorable court now is at page 5. The review petition. The impugned order is annexed at A, page 5 of the review. In view of dismissal of the writ petition, IA number 1 of 2009 does not survive for consideration and it is accordingly dismissed. So, without considering this IA on merits, whether the petitioner is entitled to seek for such a relief or not, this honorable court, without any reasoning, dismissed my petition as well as this IA. So, this IA which is dismissed without any reasoning and which is contrary to law, I filed this review before this honorable court seeking for rectification of the same. Therefore, my review petition.
When the order was being dictated, what you were doing?
My lords, this was reserved for orders and then it was passed.
It appears, let's say, it was not a reserved matter. The dictation was given in open court.
No. It was reserved.
But IA for amendment was filed before the civil court for replacing the prayer of specific performance with the prayer for damage. The court rejected on the basis telling that it could change the nature of suit, challenging that the writ petition was filed. Now, when the writ petition was pending, the IA is filed seeking the leave of this honorable court to withdraw an application whose fate is already been decided. The IA, para 7 of the IA, not only kindly para 7 of the IA which was before the writ petition court, writ jurisdiction. IA says, it is towards the end it says, I submit that the petitioner may be permitted to withdraw IA number 2 filed in OS so and so, and permit the petitioner to seek alternative remedy to direction to the respondent to refund the amount received from the petition along with the interest of 24%, etc. Now, there is no point in withdrawing an application which state is already decided and which is challenged before this honorable court. Now, the main question here remains whether an IA of this nature can be maintained. IA seeking for amendment of replacing the entire prayer. The original prayer was to seek for specific performance. During the course of the trial, they found that that particular prayer can't be maintained, and they seek to replace the prayer in order to seek for damages, the relief of damages. It could have been an alternative prayer at that point in time itself. And on this basis, the court had rejected it since the nature of the proceedings would change. And when the idea was posted for hearing, considering all these factors, this writ petition itself was dismissed. Considering that the court had rightly rejected the application. My lord, there is no bar for them to file a fresh application if they wish to.
One minute. Yes, either the order sheet the previous disposal of matter. Yes.
My right to seek for an alternate relief in lieu of specific performance is bound by section 22 of the specific relief. Now, please,
Sir, we are not on that point now. We are not on that point. The point is your writ petition dismissed according to you. During pendency of IA 1/19, the writ petition ought not to have been dismissed. That is all. If that dismissal becomes incorrect and if the writ petition is restored, then you can proceed further about your entitlement. So your ground is only that on that particular day, the matter was listed only to hear on IA 1/19. This court was not justified in disposing of the main writ petition.
Writ petition and without giving reasons on IA 1 of 2019.
You are present on the said day when the order was passed. What is your submission?
No, that this petition couldn't have survived. The immaterial of the IA was considered or not. The petition itself couldn't survive. That was the reason it was rightly rejected by this one. The entire prayer was to change the nature of the suit. The amendment which would change the nature of the suit. This one, I would cite the decision of the Honorable Supreme Court, my lord.
Not necessary.
My lord, the nature of proceeding itself couldn't be changed pursuant to amendment application. That being the case, that was maybe the stage it was for hearing of the IA, but IA itself was infectious. But there was no need to withdraw an IA. The IA what they are seeking for is they are seeking to leave of this honorable court to withdraw an application which has already come to a conclusion by the trial court. That being the case, they couldn't have withdrawn also. That IA itself was infectious in light of the impugned order. Once the IA has been decided, that is when the writ petition has arisen. As is that IA again seeking to withdrawal wouldn't survive.
Here I sought for change of relief. My learned friend has corrected something.
Now, how do you see? What is your response to her contention that the question of withdrawal of an IA which has already been heard, decided on its merit, and against which a writ was filed, would not arise?
On that given date, when IA 1 of 2019 was heard, my submission was only on seeking for an alternate relief. At that point in time, the IA was not disposed of. But since this matter came to be reserved for order, and instead of an order on IA 1 of 19 being passed, the order on merits came to be passed. So now on record it looks that my IA 2 of 2012 filed before the trial court does not survive for withdrawal at all. Where in fact the matter was listed for hearing on IA 1 of 2019.
Original order copy. The order sheet. Yeah, please receive. Present petitioner as a plaintiff in OS number 5862/2005 on the court of the learned 40th additional city civil judge and city civil and session judge at Bengaluru had instituted a suit against the present respondent. Instituted a suit in OS number so and so had prayed for relief of specific performance of an alleged contract against the present respondent, who was the defendant there. During pendency of said suit for specific performance, the plaintiff, bracket the petitioner therein, filed an interrogatory application under Order 6/17 CPC, bracket IA 2/2012. Seeking permission to amend his claim, including the prayer column, in the form of incorporating an alternate prayer for refund of the alleged earnest money and damages. After contest, this IA came to be dismissed by the order of the trial court dated 24/2/2014. Challenging the same and seeking quashing of the said order passed by the trial court on IA 2/2020 to 2/2012. In the suit filed a writ petition before this court with WP number 33950/2014. During pendency of the writ petition, the petitioner also filed. The petitioner filed interrogatory application IA 1/19 under section 151 of CPC, read with Article 227 of the Constitution of India. For 3 reliefs. Small Roman 1. Taking permission to withdraw IA number 2 filed by the petitioner as a plaintiff in OS number 5862/2005. Practically challenging the order passed upon which IA WP 33950/2014 was filed. Close the bracket. Small Roman 2. Seeking permission to the petitioner of the plaintiff to seek an alternate relief in the plaintiff for a direction to the respondent to refund the amounts that have been received by the respondent from the petitioner, along with interest thereupon. 3. Seeking permission to the petitioner of the plaintiff to prosecute the suit from the stage as it stood prior to filing IA number 2 in OS number 5862/2005. This court by its order dated 7/2/2019 dismissed the said writ petition on its merit, and also observed that in view of the dismissal of the writ petition, IA 1/19 does not survive for consideration. As such, the said IA, the IA also accordingly stands dismissed. It is seeking the review of the said order dated 7/2/2019, passed in WP number 33950/2014. The petitioner has filed the present petition. The Counsel for the petitioner submitted that On 7/2/2019, the matter was listed in orders to hear on IA 1/19. As such, he was under the impression that IA number 1/19 would be heard and decided.
Strict for compliance of office objections, wherein the office objections was prepared and the application was heard.
It was listed in the orders list for compliance of office objection on the IA. However, on the said day, the court decided to hear on IA 1/19 and reserve the matter for orders. When the order was pronounced, the main writ petition itself was disposed of and the IA 1/19 was dismissed without hearing the said IA as such. There is an error apparent on the face of the record, thus it requires a revisit. Next, learned counsel for the respondent in her argument submitted that it was after hearing both sides on the merit of the case, the writ petition came to be disposed of on 7/2/2019. As such, the question of the petitioner being an impression that matter was heard on IA 1/19 alone was unfounded one. She further submitted that when IA number 2 of 2012 filed in the trial court has already been heard and decided on its merit by the trial court and the same was challenged in the writ petition by the plaintiff, the question of withdrawing the said IA would not arise. She also contended that in the case of filing IA 1/19, the petitioner has attempted to get his IA 2/12, which was rejected, as impliedly allowed. Next line. A perusal of the records in WP 33950 of the 2014 are also placed before me. That record was perused carefully. The order sheet shows that was taken up by my predecessor in the roster, by the previous bench on 7/2/2019 in the open court, and after hearing both sides, the final order in the writ petition was dictated in the open court and the matter was disposed of. Therefore, the very first contention of the petitioner that the orders were reserved and it was pronounced at a later date is not a true statement, not a true and correct statement. Therefore, at the first instance, it can be, therefore, at the threshold itself, it can be noticed that it is after hearing both sides and in the presence of the learned counsel from both sides, this court heard the writ petition on May and proceeded to dictate the final order in the open court. As such, the contention of the petitioner that he was under an impression that court would pronounce the order on IA 1/19 but not on the main petition, and also that it had reserved the matter for pronouncement of orders or unfounded one. On the other hand, even when the court was dictating the order, the petitioner had every opportunity to clarify to the court that his argument was confining to IA 1/19 but not on the main petition. As such, the court need not have to dispose of the main petition. Such an attempt was not made. On the contrary, he waited patiently and invited a final order on the writ petition on its merit, and only since the said final order is not palatable to him and not in his favor, probably he has come up through this revision petition. Correct. Secondly, a perusal of IA 1/19 also would go to show that the prayer made in the said IA are as mentioned above. The very impugned order challenging which WP 33950 of 2014 was filed by the petitioner or the plaintiff was rejection of his IA number 2, which was filed by him under Order 6, Rule 17, CPC, seeking incorporation of certain paragraphs in the plaint, including the prayer column as an amendment, which also included amending the prayer by introducing a different prayer for refund of the alleged advance amount and also for damages in this matter, when very same prayer for amendment was rejected by a considered order, which was the subject matter of challenge in WP 33950 of 2014. And when the very writ petition also came to be dismissed, thus not interfering in the impugned order passed by the trial court on IA 2/2012. The question of either considering or allowing IA 1/19, which is also filed seeking permission to the petitioner to seek an alternative relief in the plaint for a direction to the respondent to refund the amounts received by the respondent would not arise. On the other hand, as rightly submitted by the learned counsel for the respondent, filing of the said IA 1/19 is nothing but an indirect way of ensuring the defeat of the impugned order passed on IA 2/12 by the trial court and also making the way smooth for allowing of the writ petition. It is under these circumstances the court, since has disposed of the main writ petition as devoid of merits and dismissed it, the question of entertaining IA 1/19 did not arise. As such, it dismissed the IA 1/19 also while disposing of writ petition as devoid of merits. Thus, there is no any error apparent on the face of the record or securing any evidence or documents which, despite the due diligence of the petitioner, could not be produced by him at the produced by it at the earliest stage of at the earliest point of time, comma. I hold that there are no grounds to review the final order passed in the writ petition on 7/2/2019. Accordingly, the review petition stands dismissed. In view of disposal of the main petition, IA 2/2019 does not for consideration. Yes. Yes. One moment. Yes.
And the allotment list. But the allotment list shops and go down from shops. These types of allot of side shop or shop come go down happens once in 20 years. Because based on the availability, they do it not this section 270 of the allotment of market yard. But there is some reservation, 17 may not get it. Allotment of property market yard rules 2014.
Allotment is weighed under which provision? Where is the allotment order?
Allotment order is annexed.
Does it mention under which provision of law the allotment has been made? So according to you, the allotment is required to be invariably required to be made under Rule 17.
Rule 17 prescribes some reservation, vertical reservation for SC, ST, physically disabled person.
Reservation in what?
Allotment. Not the moment my lot may require my lot to Rule 17 of allotment of property in market yards.
Which rule you are reading?
Not 17. Not yet. Reservation of site except from
Yes.
site shops, not only site shops and Guru to be allotted to allotted by the marketing committee. Such number as may be prescribed by the state government from time to time to be reserved in each category of allotment in respect of person belonging to scheduled caste, scheduled tribe. Out of the shop sites, shop go down, be allotted by the marketing committee. About 2% may be reserved in each category for allotment in favor of physically challenged person and ex-service person. But this rule came to be amended on 24 to 2022, where they have, I have incorporated that notification of Annex E, where 10% are being.
No, you show me that in the rule. If this book is latest, it should contain the said rule also. When that was amended, that rule. Sir, you first tell me when that rule was amended. When that rule was amended, I'm asking you a date.
24 to 2022.
24 to 2022. Therefore, in the old edition book, we are not able to get that. Yes. You have produced the notification where it.
Annexure, my lord gets it. Annexure D, my lord, type to page 30. Annexure D, my lord gets it. Also, my lord directed me to file a paper copy which are filed. 24 to 2020.
1 minute. Annexure D.
D, please, my lord, in page 28. Annexure D, my lord gets it. Notification, government of Karnataka number.
One moment. You appear for the respondent. You do not dispute annexure D. So that document, that notification, you do not deny or dispute the correctness. No, I will come to that. But this is the notification.
28.
Annexure D, my lord. To last but one time.
Yes, one moment. Yes.
Last but one line, my lord.
Yes.
Not they declare that 10% for women who have possessed a license issued by the auditing committee. But the petitioner fairly falls there.
Fine. I will go to that. When this amendment came into effect?
Exactly 30 days to the notification.
No. Does it say that on the 31st day, the notification would automatically come into effect as an amendment? No. I'm asking you a question. ನಾನು ಯಾವುದನ್ನೇ ಒಂದು ನಿರ್ದಿಷ್ಟವಾಗಿ ಸ್ಪೆಸಿಫಿಕ್ ಡೇಟ್ ಕೇಳಿದ್ರೆ ನೀವು ಬೇರೆದೇ ಉತ್ತರ ಕೊಡ್ತೀರಲ್ಲ. ನಾನು ಯಾವ ಡೇಟಿನಲ್ಲಿ ಅದು ನೋಟಿಫಿಕೇಶನ್ ಆಗಿದೆ ಇದಂದ್ರೆ ಸರ್ ಅನೆಕ್ಷರ್ ಡಿ ಅಂತೀರಿ. ಇಲ್ಲಿ ಯಾವ ಡೇಟಿನಲ್ಲಿ ಅಮೆಂಡ್ಮೆಂಟ್ ಆಗಿದೆ ಅಂದ್ರೆ ಆಫ್ಟರ್ 30 days ಅಂತೀರಿ. ಐ ಆಮ್ ಆಸ್ಕಿಂಗ್ ಯು ದಿ ಸ್ಪೆಸಿಫಿಕ್ ಡೇಟ್ ವೆನ್ ದಿ ರೂಲ್ 17 came to be amended.
There was a proposal for a notification, my lord, as annexure D was read, my lord.
Yes.
24/2/2022, a proposal was made and it was invited for objections, my lord, as already gone through the annexure D. Exactly 30 days to that, it could become solidified, my lord. Annexure E subsequently, my lord, not annexure E subsequently, first respondent himself, not declares, not first para. Annexure E. 22 ಸಾಲಿನ ಅವಯವ ಕೃಷಿ ಕಾರ್ಯ ಮಾರುಕಟ್ಟೆ ಸಮಿತಿಗೆ ಲೈಸೆನ್ಸ್ ಪಡೆದ ಮಹಿಳೆಯರು ಪ್ರಾಧಿಕಾರ ನಿರ್ದೇಶಕನ ಗುಣಗೊಂಡು ಅಂಗಡಿ ಮತ್ತು ಗೋಡೌನ್ಗಳು ಹೆಚ್ಚುವರಿ 10 ಮೀಸಲಾತಿಯನ್ನು ಘೋಷಿಸಲಾಗಿದೆ. This they bring to my notice, my lord. Under this category, I would have written, my lord, that I should be eligible candidate where my name has been.
1 minute. Impugned order is at
Annexure F, my lord, where my name doesn't find.
yes. Annexure F. 1 minute.
It is a list of allotment.
List of allotment. What is the date of the list of allotment?
List of allotment is, my lord, it is on 25/2/2022.
So allotment was made on 25/2/2022. Yes.
This only list, my lord. Other process awaited. Since I gave representation, now altered, my lord, noticing that amendment, my lord, I given representation to first respondent as well as third respondent, but prepared the list. Now they have started, my lord.
That is between you. The court has got nothing to do on that regard. ಅವರು ಹರಿಬರಿಯಲ್ಲಿ ಮಾಡಿರ್ತಾರೋ ಅಥವಾ ನೀವು ಹೇಳಿದ್ರಿ ಅಂತ ಹೇಳಿ ಅದನ್ನ ವರ್ಷಾನುಗಟ್ಟಲೆ ಪೆಂಡಿಂಗ್ ಇಡ್ತಾರೋ ನಿಮ್ಮಿಬ್ಬರ ನಡುವೆ ಇರೋ ವಿಚಾರ. ನನಗೆ ಸೇ ದಿ allottees list was published on 25/2/2022. Whether as on the date of publication of the list of allottees, was there any reservation?
As on the date 25/2/2022.
No reservation.
Notification, the date earlier declaring 10%. That would
As,
ಮತ್ತು ನೀವು ನನ್ನ ಪ್ರಶ್ನೆಗೆ ಉತ್ತರಕ್ಕಿಂತಲೂ ಜಾಸ್ತಿ ಹೇಳ್ತಿದ್ದೀರಿ. As on the date of publication of the list of allottees, admittedly there was no reservation. No reservation. Then how you have agreed? You have not agreed at all. Your prayer is that you are entitled for 10% reservation. As on the date of allotment, there was no reservation. A draft would be only a proposal unless it finds a place in the statute book as an amendment to the existing rule. It cannot be enforced because it is only a proposal. It can be withdrawn at any later time before making it a law, or can be altered, amended, modified.
Or if it is gazetted, my lord, it is applicable.
Yes. Therefore, as on the date of allotment of 25/2/2022, there was no reservation. When there was no reservation, you cannot claim as a matter of right of your entitlement under reservation. So that is the only ground upon which you have come and you have challenged the allotment letter. If you have got any other remedy, you can pursue them. If you could be able to solve the allotment and further proceeding there, that shows that you are a very influential person. So that you can make use of those influences or your approach to them and get allotment done. That is between you and him. This court cannot say anything in that regard now.
My lord, you do not what had happened now. Since the first respondent himself had written annexed deed to the entire.
Sir, in the ignorance of law, whatever they say, they can't be in estoppel against statute, right? When there is no law, if they say anything, then show it to them and tell them that, say, you have promised me this and do this accordingly. If they don't do that, then you may get a separate cause of action. But as a matter of right that you were entitled for reservation as on the date of allotment, as such, the allotment letter has to be quashed.
Prior year, as my lord right here is not prior year, quash may not survive.
Prior year does not survive.
As my lord noticed, there was no reservation as on the date of annexed year. Prior B, my lord.
Prior B, that is for you and him. Sir, representation allotment ಕೊಡೋರೆಲ್ಲ ಕೊಟ್ಟರು ಅಂತ ಹೇಳಿದ್ರೆ ಲೀಗಲಿ ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಇದ್ರೆ ಮಾತ್ರ ಒಂದು ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಕೊಟ್ಟು ಕೂಡಲೇ ಅದು ಎಲ್ಲದಕ್ಕೂ ರೆಸ್ಪಾಂಡ್ ಮಾಡಲೇಬೇಕು ಅಂತಾರೆ. ದೇರ್ ಇಸ್ ನೋ ಎಂಡ್ ವಿತ್ ದಿ ಪಬ್ಲಿಕ್ ಅಥಾರಿಟಿ. PDA 4,000 ಸೈಟ್ಗಳಿಗೆ ಅಪ್ಲಿಕೇಶನ್ ಕರೀತದೆ. 2.5 ಲಕ್ಷ ಅಲಾಟೀಸ್ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕ್ತಾರೆ. ಅಲಾಟ್ಮೆಂಟ್ ಆಗಲ್ಲ ಅಂತ ಹೇಳಿ 1.5 ಲಕ್ಷ ಜನ ಅವ್ರು ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಕೊಡ್ತಾರೆ. 1.5 ಲಕ್ಷ ಜನಗಳಿಗೂ ಒಬ್ಬೊಬ್ರು ನೀವು ಅಟೆಂಡ್ ಮಾಡ್ತಾ ಹೋಗ್ಬೇಕಂತ ಹೇಳಿದ್ರೆ BDA ಒಂದು ಸಪರೇಟ್ 5,000 ಜನ ಸ್ಟಾಫ್ ಅನ್ನು ಎಂಗೇಜ್ ಮಾಡಿ ಅದಕ್ಕೊಂದು ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಇಡಬೇಕು. ಪ್ರೇಮ ಫೇಸಿ ನೀವಿಲ್ಲಿ ತೋರಿಸ್ಬೇಕು ನಿಮಗೊಂದು ಮೆರಿಟ್ ಇದೆ, ನಿಮ್ಮ ರೆಪ್ರೆಸೆಂಟೇಷನ್ಗೆ ಬೆಲೆ ಇದೆ, ಆದ್ರೂ ಅವರು ಅದನ್ನು ಕನ್ಸಿಡರ್ ಮಾಡಲಿಲ್ಲ. ಅವಾಗ ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಕನ್ಸಿಡರ್ ಮಾಡಿ ಅಂತ ಡೈರೆಕ್ಷನ್ ಕೊಡ್ಬೇಕಾಗ್ತದೆ. ನಾವು ದುರಂತ ಏನಾಗಿದೆ ಅಂತ ಹೇಳಿದ್ರೆ 180 ಮ್ಯಾಟ್ರು I have given a representation not considered. Yes, take down to consider their representation within 4 weeks from today. WP stands disposed of. ದಿವಸಕ್ಕೆ 40 ರಿಟ್ ಪೆಟಿಷನ್ ಡಿಸ್ಪೋಸ್ ಆಯ್ತು, ಮುಗಿದೋಯ್ತು. ನಾವು ಖುಷ್, ನೀವು ಖುಷ್. ಅವ್ರಿಗೇನು ಗೌರ್ಮೆಂಟ್ ಅಡ್ವೊಕೇಟ್ ಒಂದು ಡಿಸ್ಪೋಸ್ ಆದ್ರೆ ಅವ್ರಿಗೆ ಡಿಸ್ಪೋಸಲ್ ಫೀ ಸಿಗುತ್ತೆ. ಪರ್ ಡೇ ಏನಾಗ್ತದೆ, ಮಲ್ಟಿಪ್ಲಿಸಿಟಿ ಆಫ್ ಪ್ರೊಸೀಡಿಂಗ್ ಆಗ್ತದೆ. To consider the representation ಅಂದ್ರೆ you should convince the court that my representation deserves consideration by the authority. Despite my consideration being deserved for, despite my representation deserving consideration by them, for unfrivolous reasons they are withholding consideration of my representation. Therefore, direct them. ಈಗ ಪ್ರೇಮ ಫೈಸಿ ನೀವು ರಿಸರ್ವೇಶನ್ ಕೋಟಾದಲ್ಲಿ ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಕೊಟ್ರೆ, ಈಗ ರಿಸರ್ವೇಶನ್ ಕೋಟಾ ನಿಮ್ಗೆ ಇಲ್ಲ ಅಂತಾರೆ, ನಿಮ್ಮ ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಹೊರಟೋಗ್ತದೆ. ಇನ್ನೊಂದು ಕನ್ಸಿಡರ್ ಮಾಡುವ ನೆಸೆಸಿಟಿಯಲ್ಲಿ ಬರ್ತದೆ. ನಿಮಗೆ ಬೇರೆ ಗ್ರೌಂಡ್ ಇದ್ರೆ ಕೊಡಿ, ಬೇರೆದೇನಾದ್ರು ಇದ್ರೆ ಕೊಡಿ, ಅವ್ರು ಮಾಡದೆ ಹೋದ್ರೆ ಬನ್ನಿ.
ದುರಂತ ನಮ್ಮಲ್ಲಿ ರಿಟ್ ಜೂರಿಸ್ಟ್ರಿಕ್ಷನ್ ಅನ್ನ ನಾವು ಅಷ್ಟೂ ಬಹಳ ಲಿಬರಲ್ ಆಗಿ, ಬಹಳ ವೇಗ್ ಆಗಿ, ಬಹಳ ವೈಲ್ಡ್ ಆಗಿ ತಗೊಂಡು ಹೋಗ್ತೇವೆ ನಾವು. ಒಂದು ಕನ್ಸಿಡರೇಷನ್, ಗಿವ್ ಎ ಡೈರೆಕ್ಷನ್, ಮುಗಿತು, WP ಡಿಸ್ಪೋಸ್ಡ್ ಆಫ್. ಅದು ಮರಿಗಳು ಹಾಕುತ್ತೆ. ಕೋರ್ಟ್ ಡೈರೆಕ್ಷನ್ ಅಂತಂದಾದ ಕೂಡಲೇ ಮುಗೀತು ಕತೆ. ಅಲ್ಲಿ ಯಾರೊಬ್ಬ ಕೇಸ್ ವರ್ಕರ್ ಇರ್ತಾನೆ, ಟು ಕನ್ಸಿಡರ್ ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಅನ್ನೋದನ್ನ ಆತ ಬರೀತಾನೆ. ದೇರ್ ಇಸ್ ಹೈಕೋರ್ಟ್ ಡೈರೆಕ್ಷನ್ ಟು ಕನ್ಸಿಡರ್ ದಮ್ ಆಸ್ ಸಚ್ ಶಾಪ್ ಟು ಬಿ ಅಲಾಟೆಡ್ ಟು ದೆಮ್. ಅದ್ರ ಮೇಲೆ 8 ಸಿಗ್ನೇಚರ್ಗಳು ಬರ್ತದೆ. ಎಸಿನೋ ಡಿಸಿನೋ ಅದೇನೋ ಇದ್ದಾರೆ, ಸೈನು ಹಾಕ್ತಾರೆ. ಎಸ್, ಹೈಕೋರ್ಟ್ ಡೈರೆಕ್ಷನ್, ಶಾಪ್ ಇಸ್ ಅಲಾಟೆಡ್. ಮುಗ್ದೇ ಹೋಯ್ತು ನೋಡಿ. ಹೆಚ್ಚಿನ ನಮ್ಮದು ಡೈರೆಕ್ಷನ್ಸ್ಗಳು ದೇ ವಿಲ್ ಬಿ ಮಿಸ್ರೆಡ್ ಬೈ ದಿ ಅರ್ಥಾರಿಟಿ. ಇಲ್ಲಿ ನಿಮ್ಮದು ರೆಪ್ರೆಸೆಂಟೇಷನ್, ರಿಸರ್ವೇಶನ್ ಅಲ್ಲಿ ನನಗೆ ಎಂಟೈಟಲ್ಮೆಂಟ್ ಅಂದ್ರೆ ರಿಸರ್ವೇಶನ್ ಇಲ್ಲ, ಹಾಗಾಗಿ ನಿಮ್ಮ ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಕನ್ಸಿಡರ್ ಮಾಡುವ ಪ್ರಶ್ನೆ ಬರಲ್ಲ. ನೀವು ಬೇರೆ ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಇದ್ರೆ, ಸಬ್ಸೆಕ್ವೆಂಟ್ ಕಾಸ್ ಆಫ್ ಆಕ್ಷನ್ ಏನಾರು ಇದ್ರೆ, ಅಲಾಟ್ಮೆಂಟ್ ಮಾಡಿದ್ರಲ್ಲೇ ನಿಮ್ಗೆ ಅನ್ಯಾಯ ಆಗಿದೆ ಅಂತಿದ್ರೆ ಕೊಡಿ ಆ ರೆಪ್ರೆಸೆಂಟೇಷನ್, ಅವ್ರಿಗೆ ಡೆಮಾನ್ಸ್ಟ್ರೇಟ್ ಮಾಡಿ. ದೆನ್ they are required to respond to your representation. ಅದು ಮಾಡಲಿಲ್ಲ ಅಂದ್ರೆ Mandamus. Please.
A woman for some percent of reservation after a very long time. The rules came in year 2014. There are a very small fragment of this women who are working at this market APMC with the license. These women
ಹೆಚ್ಚಿನ ಇಂಥ ಲೈಸೆನ್ಸ್ಗಳು ಫೇರ್ ಪ್ರೈಸ್ ಡಿಪೋ, APMC ಮಾರ್ಕೆಟ್, ಎಕ್ಸೈಸಿನ ಲಿಕ್ಕರ್ ಲೈಸೆನ್ಸ್ಗಳು ಎಲ್ಲ ವುಮೆನ್ ಹೆಸರಲ್ಲಿ ಇರ್ತದೆ. ಆ ವುಮೆನ್ಗಳು ಅಂಡಿ ಮುಖನೇ ನೋಡಿರಲ್ಲ. ದೀಪಾವಳಿ ಪೂಜೆಗೋ ಆಯುಧ ಪೂಜೆ ದಿವಸಕ್ಕೂ ಹೋಗಿ ಪೂಜೆ ಮಾಡಿ ಪ್ರಸಾದ ಕೊಟ್ಟು ಬಂದ್ರೆ ಮತ್ತವ್ರು ಅಂಡಿದ್ ನೋಡಲ್ಲ. ನಡೆಸೋದೆಲ್ಲರೂ ಯಜಮಾನ್ರೆ ನಡೆಸ್ತಾರೆ. ಈಗಲಿ ವಿಮೆನ್ ಎಂಟರ್ಪ್ರೈಸ್ ಇಲ್ಲ ಅಂತ ನಾನು ಹೇಳ್ತಾ ಇಲ್ಲ, ಅಥವಾ ಯು ಡು ನಾಟ್ ಡಿಸರ್ವ್ ಅಂತ ಹೇಳ್ತಾ ಇಲ್ಲ. ನಾನು ಹೇಳ್ತಾ ಇರೋದು, ನಿಮಗೆ ರಿಸರ್ವೇಶನ್ ಫೆಸಿಲಿಟಿ ಬರಬೇಕು ಅಥವಾ ಬರ್ತದ ಅಂತಾದ್ರೆ ಈ ರಿಟ್ ಪಿಟಿಷನ್ ಅಲ್ಲಿ, ಈ ಗ್ರೌಂಡ್ ನಲ್ಲಿ, ಈ ಹಂತದಲ್ಲಿ ಸಾಧ್ಯ ಇಲ್ಲ. ಯು ಮೇ ಆಲ್ರೆಡಿ ಹ್ಯಾವ್ ಎ ಸೆಪರೇಟ್ ಕಾಸ್ ಆಫ್ ಆಕ್ಷನ್ ಟು ಚಾಲೆಂಜ್ ದ ವೆರಿ ಸೇಮ್ ಆರ್ಡರ್, or you may get another cause of action, but not in this writ petition at this stage in the present manner. ಬರಲ್ರಿ, ಹಾಗ ಆಟೋಮೆಟಿಕ್ಲಿ ಬರೋಲ್ರಿ. ಎರಡನೇದಾಗಿ ಅವ್ರು 1 ಮಂತ್ ಆದ್ರೂ ಮೇಲೂ ಮಾಡ್ಲಿಲ್ಲ ಅವರು ಅಲಾಟ್ಮೆಂಟು. 1 ಮಂತ್ ಆದ್ರೂ ಮಾಡ್ಲಿಲ್ಲ. ಯಾಕೆ ಅದನ್ನ ಬೇಗ ಮಾಡಿದ್ರು ಏನು ಅನ್ನೋದನ್ನ ಇಲ್ಲಿ ಹೇಳಲಿಕ್ಕೆ ಆಗಲ್ಲ. ಅದು ನೀವು ಅರ್ಥ ಮಾಡ್ಕೊಳ್ಬೇಕು. ನೀವು ಅದನ್ನ ಹೇಗೆ ಟ್ಯಾಕಲ್ ಮಾಡ್ಬೇಕು, ಹೇಗೆ ಅದನ್ನ ನೀವು ಮಾಡ್ಬೇಕು. ಐ ಕೆನಾಟ್ ಬಿ ಯುವರ್ ಕೌನ್ಸಿಲ್. ಅಲ್ಲಿದ್ರೆ ಹೋಗ್ಲಿ ಬಿಡು, ಅದು ಹುಗ್ಗಿಯಿಂದ ಹೊರ ಚಿರೋಟಿ ಸಿಕ್ತು ಅಂತ ಹೇಳಿ ಇನ್ನೊಂದೇ ರಿಪಿಟಿಷನ್ ಬೇರೆ ರೀತಿನೇ ಹಾಕಿ ಅದ್ ಏನ್ ಪರ್ಪಸ್ ಮಾಡ್ಬೇಕು ಮಾಡ್ಕೊಳ್ಳಿಕ್ಕೆ ಅವಕಾಶ ಇದೆ, ಮಾಡಬಹುದಿತ್ತು. ನೀವು ಅದನ್ನ ಮಾಡ್ಲಿಲ್ಲ.
complete the amendment process and provide me. That was the reason for this. But then they said, now we have not received any objection that which they orally mentioned, but it requires some time to gazette the document, being apprehension that I will do.
ಇಫ್ ಅಂಡ್ ಬಟ್ಸ್ ಯಾರೋ ನಿಮ್ಗೆ ಓರಲಿ ಹೇಳಿದ್ರು, ಇನ್ನೇನೋ ಮಾಡಿದ್ರು, ಅಂತದ್ರ ಮೇಲೆ ಇದನ್ನ ಮಾಡ್ಲಿಕ್ಕೆ ಬರಲ್ಲ ಹೋಗ್ತಿಲ್ರಿ. ಆದ್ರೆ ಅಂತದ್ ಏನಾರು ಆದ್ರೂ ಕೂಡ ನಿಮಗೆ ಕಾಸ್ ಆಫ್ ಆಕ್ಷನ್ ಅಂತೂ ಸಿಕ್ಕೇ ಸಿಗ್ತದ. ಯಾಕೆಂದ್ರೆ ಅಪ್ಲಿಕೇಶನ್ ನೀವು ಬಿಫೋರ್ ಅಲಾಟ್ಮೆಂಟೇ ಹಾಕಿದ್ದೀರಿ ಅಲ್ವೇ? ನೀವು ಬಿಫೋರ್ ಅಲಾಟ್ಮೆಂಟ್ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿರೋದ್ರಿಂದ anticipating some amendment in some law, we cannot stay the proceeding. ಆದರೆ ಆ ಲಾ ಬಂತಂತ ಆದ್ರೆ, ರಿಟ್ರಾಸ್ಪೆಕ್ಟಿವ್ ಆಗಿ ಬಂತಂತ ಆದ್ರೆ, ನೀವು ಎಲಿಜಿಬಲ್ ಅಂತ ಆದ್ರೆ, ಅದು ಯಾರಿಗೆ ಅಲಾಟ್ಮೆಂಟ್ ಆಗಿದ್ರು ಕೂಡ ಅದು ಕ್ಯಾನ್ಸಲ್ ಆಗ್ತದೆ ಅಲ್ವೇ? ಒಂದೇದು. ಎರಡನೇದಾಗಿ ನಿಮಗೆ ಅದು ಅಲಾಟ್ಮೆಂಟ್ ಲಿಸ್ಟ್ ಅನ್ನ ಈಗಲೇ ನೀವು ಅದನ್ನ ಚಾಲೆಂಜ್ ಮಾಡಬೇಕಿತ್ತು ಅಂತಾದ್ರೂ ಕೂಡ ನಿಮಗೆ ಬೇರೆ ದಾರಿಗಳು ಇತ್ತು. ಆರ್ಟಿಕಲ್ 226 ನಲ್ಲಿಯೇ ಬರ್ಲಿಕ್ಕೆ ನೀವು ಅದನ್ನ ಬರಲಿಲ್ಲ. I cannot tell what you should have mentioned or raised grounds. Yes, take down. present petitioner claiming herself to be one of the applicants for the allotment of shops and godowns in the APMC market at Mysuru, alleging that the list of allottees at Annexure F and dated 25/2/2022 does not, where her name had approached this court seeking a writ of certiorari for quashing the said Annexure F dated 25/2/2022. She has also sought for writ of Mandamus, seeking direction to the first respondent to consider her alleged representations dated 8/3/2022 and 11/3/2022. Against the first and third respondent. After hearing, merit ಮೇಲೆ ಏನು ಹೇಳಲ್ರಿ. After hearing the arguments of the learned counsel for the petitioner, when the court proceeded to dictate order on the writ petition, the learned counsel for the petitioner submits that he would not press the present petition. However, reserving his liberty to approach the court on the subsequent causes of action accrued to him, if any, in the matter. In the light of the above submission, the writ petition stands dismissed as not pressed.
Amendment 22.
Yes, please.
The petition of the permanent residents of the village of Ayamapura and petition it pertains to the drawing of the transmission line that will be drawn through the villages of various villages in the Reservation. On 9/11/2021, a notice came issued by the Office of the District Commissioner Madikeri, which was pertaining to this impending drawing of transmission line. Subsequent to that, in that notice, which I have produced at Annexure D, they say that they will call for a meeting on 25/11/2020 to discuss the impending drawing of transmission lines and any issues pertaining to compensation, etc. They have called upon the agriculturalists and the landowners of all the aforementioned.
One moment. Annexure D.
On page 26.
Yes, a meeting was called.
He was called for on the date as mentioned in the 25. This meeting was supposed to be scheduled. This meeting did not take place. Thereafter, what has happened is in the village of Aimamura, wherein the petitioner they have started drawing the transmission line.
They started drawing the transmission.
The month of December in that particular village, the village of Aimamura, they started drawing transmission lines. And on 7th March, they have entered the property, the private property of the petitioner, and they have erected poles. So all over that private property. This was done without any prior intimation. It was done without any.
Legally, what they were required to do?
Can you take the Electricity Act 67?
You said that the meeting was not held, which was scheduled as per Annexure D. You said the meeting was not held on 15/11/2021, right? What your Annexure E says, the document produced by you?
Annexure E pertains to resolution passed by the Gram Panchayat of Chennai, which comes where the village of Aimamura comes under the ambit of Gram Panchayat. But in this resolution, they discuss the lack of clarity and lack of intimation provided to anyone in the village with regards to.
So kindly read the first 3 lines of that resolution. You are required to. When you as a council produce a document in a regional language, when the court asks you to read it, you should read it. Since how long you are there in state of Karnataka? By birth. By birth. So being in the state, in this state, since your birth, practicing a profession like advocacy, relying upon the colloquial language, regional language, document, you are unable to read what the document is. This is the, what to say, a regrettable matter or pity. Probably this is the only state where without knowing Kannada, a person can flourish. A person without knowing Kannada language authors a document or any script or any literature, probably in Kannada, relies upon the documentations in Kannada, but unable to tell what that document and what it says. They have not even produced the translated copy also. That means when you have not even produced the translated copy, even the court asks you to read it, you are expected to read it. ಕಳೆದ 20 ವರ್ಷದಿಂದ ಅನೇಕ ಮಂದಿ ವಕೀಲರನ್ನ ನೋಡಿದ್ದೇನೆ ನಾನು. ಭಾಷೆ ಕಲೀಲಿಕ್ಕೆ ಒತ್ತಾಯ ಅಂತಲ್ಲ ಹೇಳ್ತಿರೋದು. ನೀವು ಒಬ್ಬರಂತಲ್ಲ, 10 ವಕೀಲರುಗಳನ್ನು ನೋಡಿದ್ದೇನೆ. ಡೆಸಿಗ್ನೇಟೆಡ್ ಸೀನಿಯರ್ ಕೌನ್ಸಿಲರ್ ನೋಡಿದ್ದೇನೆ. ಐ ಡು ನಾಟ್ ನೋ ದಿ ಲೋಕಲ್ ಲ್ಯಾಂಗ್ವೇಜ್, ಮೈ ಜೂನಿಯರ್ ವುಡ್ ಡೂ ಇಟ್ ಅಂತ ಹೇಳೋರನ್ನು. 30, 40, 50, 60 ವರ್ಷ ಆಗಿ ಇದೇ ಸ್ಥಳದಲ್ಲಿದ್ದು, ಇದೇ ರಾಜ್ಯದಲ್ಲಿದ್ದು, ಇಲ್ಲೇ ಇದ್ರು ಕೂಡ ಐ ಡು ನಾಟ್ ನೋ ಕನ್ನಡ. ಅಟ್ಲೀಸ್ಟ್ ನಮ್ಗೆ ಕೆಲಸಕ್ಕೆ ಎಷ್ಟು ಬೇಕು ಅಷ್ಟನ್ನಾದ್ರೂ ನಾವು ಸ್ಥಳೀಯ ಭಾಷೆ, ಅದು ಕನ್ನಡವೇ ಆಗಲಿ, ತಮಿಳೇ ಆಗಲಿ, ತೆಲುಗೇ ಆಗಲಿ, ಒರಿಯಾ ಆಗಲಿ, ಅಸ್ಸಾಮೀಸ್ ಆಗಲಿ, ಸ್ಥಳೀಯ ಭಾಷೆ ನಮ್ಮ ಕಾರ್ಯಕ್ಕೆ ಎಷ್ಟು ಬೇಕೋ ಅಷ್ಟನ್ನು ನಾವು ಬಲ್ಲವರಾಗಿರ್ಬೇಕಲ್ವೇ? Annexure, he says that the meeting was held on 15/11/2021. Your own panchayat has said that the meeting was held. You said that meeting was not held. Your own document says that meeting held. So meeting was not held cannot be a ground available to you now. Yes. What are the next other grounds?
The ground is that I was not provided any compensation. Respondent having entered my property and having erected poles. That is the other ground.
Which section you said?
Section 67 under work of licensing.
Of license. What it says? Which subsection?
67 clause 3.
Yes.
Licensee shall, in exercise of any of the powers conferred by or under this section and the rules may be thereunder, cause as little damage, detriment, and inconvenience as may be, and shall make full compensation for any damage, detriment, or inconvenience caused by him or anyone employed.
Yes.
In this case, one of the petitioners, they don't have any grievance against the drawing of the transmission line. The evidence is that they have entered their private property, erected poles, and they're preparing now to draw the transmission line without having duly compensated them.
This 67(3) does not lay down any condition precedent for drawing the electric line. It entitles you for damages. Are there not any other provision which says that, say, before drawing the lines in your land, they should assess the compensation payable to you? ಏನು ಕೊಟ್ಟಿದ್ದೀರೇನ್ರಿ ಅವ್ರಿಗೆ ಏನಾದ್ರು, ಅಥವಾ ಎಷ್ಟಕ್ಕೆ ಅವರಿಗೆ ಎಷ್ಟು ಏರಿಯಾ ನೀವು ಅದನ್ನ ಯೂಸ್ ಮಾಡ್ಕೊಳ್ತಾ ಇದ್ದೀರಿ, ಎಷ್ಟು ಕೊಡ್ಬೇಕು ಅಂತ ಏನಾದ್ರು ನೀವು Para 4 of yes. Yes.
Pertaining to the laying of the transmission lines in the aforementioned village. However, the respondent number 2 has the erection of towers and laying of transmission lines in the villages of Aimangala in the month of December and on 7/3/2022. And on 7/3/2022, they have erected poles over the property of the petitioners. There is no any such evidence or any document to show. It is there. All the proceedings will be completed.
Probably the Lagrid Council is not even able to convince the court that, say, before laying down the electrical line, what are all the things that you are required to do? He is unable to bring to the notice of the court those aspects. So that being the situation, how can he lay his hand on those documents of drawing the line and which land it crosses and how many work has been done? But as the actual possessor and cultivator of the land, he is telling that, say, his land is being used by you now. You can ascertain it, confirm it from your end. ಹೌದ್ರಿ ಅವ್ರು ಹಾಕ್ಲಿಲ್ಲ ಒಪ್ಪು ಒಂದು ಮಾತ್ರಕ್ಕೆ ನೀವು ಸ್ಟ್ರೈಟ್ ಅವೇ ಅವ್ರು ನಾವೇನು ಮಾಡ್ಲೇ ಇಲ್ಲ ಅಂತ ಡಿನೇ ಮಾಡಬೇಡಿ. ಅವ್ರಿಗೆ ನೀವು ಅಪಿಯರ್ ಆಗ್ತಿಲ್ವೇ? ಯಾರಿಗೆ ಸರ್ವ್ ಮಾಡಿದ್ದೀರಿ ನೀವು? At the submission of law, counsel for the petitioner raised the memorandum of petition. After hearing the submission, and after the submission of Laurent CGP, upon whom the advance copy is served for respondent number 1, respondent number 1, I am of the view that before proceeding to pass any interim order in this matter, before proceeding to consider the request for interim order, the respondents be heard in this matter. Accordingly, issue emergent notice to the respondent. Laurent CGP is notice for respondent number 1. Upon whom he have served for KPTCL petitioner to pay the necessary process and furnish copies in the registry within a day from today to ensure the service of notice upon respondent number 2 and 3. List the matter on 18/4. Yes.
23 Shri Venkatesh R. Bhagat for the petitioner Balkrishna Shastri for the respondent. And 23
Commissioner. ಒಂದೇ ಸರ್ತಿಗೆ ಸ್ಕೆಚ್ ಅಂದ್ರೆ ನನಗೆ ಏನು ಅಂತ ಅರ್ಥ ಆಗ್ಬೇಕ್ರಿ, ಯಾವ ಕೇಸು ಏನು ಅಂತ. Two for what? Commissioner was appointed.
He identified the property and he made 4 requests. The 4th request, all other requests are accepted, except 4th request. Therefore, having necessarily a amendment to the village and the regulation. That exists. Entire commission report, all JDR accepted, except point number 4. Point number 4 is that
who has made the prayer for the alteration of the map, village map? Commissioner by himself, not by either of the parties.
Excluding that, 4 commissioners accepting that.
The counsel for the petitioner alone is physically present. The counsel for the respondent this matter 12, 4. So your ligament is now cured.
24, 25, and 26 are absorbed. 27, no treaty. Number 27.
I appear for the respondents 1 and 10, my lord.
Yes, Babu Narayan for R 1 and 10. For R 9.
The question involved was of res judicata, right? Which is the application that came to be rejected? No, the annexure.
If it is application, it was the application of appointment of commission.
Yes, please. In the trial court, it was the defendant who filed the application. In the trial court, it was the defendant who filed application. In the appeal, it is the plaintiff who has filed the application. Yes. The suit came to be dismissed.
Also. Transfer the defendant matter to the High Court because of the evidence where the defendant then.
Not on this IA. Not on the IA for commissioner appointment.
They are not challenging. Previously, we made the application, even made the application that was rejected, that was they were opposed by them. That was not challenged before the court. Then we have filed the field against the court was transferred the matter to the High Court for further evidence and other things. The court was dismissed. Then they have filed the appeal before the principal court will let RA.
You are for the defendant.
D2 email.
Yes, please. No, whether in the impugned order, apart from the res judicata, whether the other grounds for the appointment of the commissioner is decided, no. Your application was disposed of only on the single point of res judicata. Why can't application be remanded to the trial court to consider on its merit, setting aside its observation that it is borrowed by res judicata? Then you will have all the grounds there.
Seriously opposite the application filed by the defendant before the original court matter regarding the appointment of commissioner. They are not, the application was rejected. But again, now they are unsuccessful in the original court matter. Now the matter is pending before the next court. They have filed this appeal. They have filed this application belatedly.
No, that you can agitate in the trial court, which is required to consider the application on its merit. It did not consider the application on merit, but it disposed the application only at the single point of alleged res judicata. If this court finds that, say, there is no element of res judicata, is not hit by res judicata, then you get all the opportunity there to agitate that why the commissioner's application, why the application seeking of commission shall not be allowed. You can bring all these aspects, including your contention, if any, that allowing the application would amount to collection of evidence. Sir, your application came to be rejected because it was totally vague. You did not even mention why you intend to seek the appointment of a commissioner. You said that, say, in order to ascertain your contention for local investigation, a commissioner is required to be appointed. They said the application is bald and vague. Application came to be rejected. That is all. That is all. Now, in their application, they have mentioned what for the commissioner is required to be appointed. What are the local investigation the commissioner is required to do, including conducting a survey, marking boundaries, etc. I am not on that point whether the survey has to be conducted or boundaries are to be marked. But I am on the point that the court did not, the first appellate court did not consider all those aspects. It only said, since a similar application has already been decided and rejected, the present application is hit by the principle of res judicata. As such, it cannot be allowed. The earlier application was not decided on the merit. Or the question that it is too vague and it does not mention what is the purpose of appointing the commissioner. Huh. Yes. Yes. Our objection, na? Para 2 ನಲ್ಲಿ ನೀವು ಹೇಳಿರೋದು ಕೋರ್ಟ್ ಕಮಿಷನರ್ ಫಾರ್ ಲೋಕಲ್ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ವಿತ್ ನೀಡ್ ಸ್ಕೆಚ್ ಅಂಡ್ ಮಾಜರ್. ಅವರು ಸ್ಕೆಚ್ ಅನ್ನ ಮಾಡಬೇಕು, ಮಾಜರ್ ಮಾಡಬೇಕು, ಬೌಂಡ್ರಿ ಡ್ರಾ ಮಾಡಬೇಕು ಅಂತಲ್ಲ. ಕಮಿಷನರ್ ಅಪಾಯಿಂಟ್ ಮಾಡ್ರಿ, ನೀಡ್ ಸ್ಕೆಚ್ ಮಾಜರ್ ಜೊತೆಗೆ ಬರಲಿ ಅಂತ. First paragraph.
Their objections filed in 2015, Procedural court. It is necessary at the very beginning to capable and of the commissioner is not made.
ಅದಲ್ಲದೆ ಹೇಳಿದ್ದಾರೆ, to collect the evidence in a suit for injunction or possession, they have to prove their title independently. ಕರೆಕ್ಟೇ ಇದು. ಅವರು ಅದನ್ನ ಹೇಳಿದ್ದಾರೆ. ನಾನು ಹೇಳ್ತಾರೆ, ನಿಮಗೆ ಅದನ್ನೆಲ್ಲ ಕಂಟೆಂಟ್ ಮಾಡ್ಲಿಕ್ಕೆ ಗ್ರೌಂಡ್ ಬರ್ತದೆ. ಯಾಕೆ ಅಂದ್ರೆ ವೆದರ್ ದ ಕಮಿಷನರ್ ಈಸ್ ರಿಕ್ವೈರ್ಡ್ ಟು ಅಪಾಯಿಂಟೆಡ್ ಅನ್ನೋ ಪಾಯಿಂಟ್ ಬಗ್ಗೆ ಅಪೆಲೇಟ್ ಕೋರ್ಟ್ ಕನ್ಸಿಡರೇ ಮಾಡಲಿಲ್ಲ. ರೆಸ್ಯುಡಿಕೇಟಕ್ಕೆ ಅಷ್ಟೇ ನಿಲ್ಸಿದೆ. ಅದೇನಾದ್ರೂ ಅಪಾರ್ಟ್ ಫ್ರಮ್ ರೆಸ್ಯುಡಿಕೇಟ, ಈವನ್ ದೇರ್ ಇಸ್ ನೋ ಮೆರಿಟ್ ಇನ್ ಅಪಾಯಿಂಟಿಂಗ್ ದ ಕಮಿಷನರ್, ದೇರ್ ಇಸ್ ನೋ ಮೆರಿಟ್ ಇನ್ ದ ಅಪ್ಲಿಕೇಶನ್, ಇಟ್ ಡಸ್ ನಾಟ್ ಡಿಸರ್ವ್ ಟು ಬಿ ಅಪಾಯಿಂಟೆಡ್, it does not deserve to be allowed and a commissioner need not have to be appointed ಅಂತ ಏನಾರು ಹೇಳಿದ್ರೆ ಅವಾಗ ಅದನ್ನ ನಾವು ನೋಡಬಹುದು. ಅದ್ರ ಬಗ್ಗೆ ಏನು ಹೇಳಲಿಲ್ಲ. ಅದು ರೆಸ್ಯುಡಿಕೇಟ ಒಂದ್ರ ಮೇಲೆ ಬಹಳ ಡೀಟೇಲ್ ಆಗಿ ಬೇರೆ ಬೇರೆ ಜಜ್ಮೆಂಟ್ಗಳನ್ನೆಲ್ಲ ಹೇಳಿ ಏನೇನೋ ಹೇಳಿ ರೆಸ್ಯುಡಿಕೇಟ ಅಂತ ಬಂದ್ಬಿಟ್ಟಿದೆ. ಆ ರೆಸ್ಯುಡಿಕೇಟ ಹೋಲ್ಡ್ ದಿಸ್ ದಟ್ ಇಟ್ ಈಸ್ ಹಿಟ್ ಬೈ ರೆಸ್ಯುಡಿಕೇಟ ಅನ್ಲಿಕ್ಕೆ ಅದು ಕೇವಲ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಅಂತದೇ ಸಿಮಿಲರ್ ಅಪ್ಲಿಕೇಶನ್ ಇತ್ತು, ಅದರ ಅದರ್ ಸೈಡ್ ಅಪೋಸ್ ಮಾಡಿದ್ರೆ ಈಗ ಅವರೇ ಅಂತದೊಂದು ಅಪ್ಲಿಕೇಶನ್ ಆಗ್ತಾ ಇದ್ದಾರೆ, therefore ರೆಸ್ಯುಡಿಕೇಟ ಅಂತ ಅಷ್ಟೇ ಹೇಳಿದೆ. ಬಟ್ ದಟ್ ಈಸ್ ನಾಟ್ ಎಕ್ಸಾಕ್ಟ್ಲಿ ದ ಇಂಟೆನ್ಷನ್ ಆಫ್ ರೆಸ್ಯುಡಿಕೇಟ್. So we'll continue after lunch.
Your Lordship, on submission, Your Lordship, serial number 18, Your Lordship. Your Lordship, on submission, Your Lordship, I have informed the petitioner advocate also respond other counsels in the serial number 18, Your Lordship. 12th was the date given, Your Lordship. 12th no maneli function is 12th and 13th, Your Lordship. It may be taken on 18th, Your Lordship. I owe apology for causing inconvenience.
ನನಗೆ ಅದರ್ ಸೈಡ್ ಬರಬೇಕು. I cannot change the.
ಮಾಡಿದೀವಿ. They were also given a concurrence, Your Lordship.
Mr. Counsel, ಅವ್ರು ಇಲ್ಲಿ ಇದ್ರೆ I can alter, otherwise I cannot.
Your Lordship,
otherwise I cannot. Who is read on my serial number 18?
Serial number 18 Shri G.K. Bhatt, petitioner.
ಯಾರು
appear ಆಗ್ತೀನಿ 2:30 I'll make a mention.
ಯಾರು ಇಲ್ದೇ ಇದ್ದಾಗ ಕೊಟ್ಟಿರೋ ಡೇಟ್ ನ in their absence I can't alter it.
Please, 18th,
yes,
2:30 I'll make a mention.
Yes.
Petitioner.
Yes.
I need to file certain documents. There is a conversion order that they are aligned to scale to produce that order. Given a week's time.
The request of the counsel for the petitioner, a week's time as spread is granted. Yes.
Interim order, let me tell you the action.
Interim order ಅಂತ ಹೇಳಿದ್ರೆ ನೀವು ಮ್ಯಾಟರ್ ಕರೆಯಲಿವರೆಗೆ ಕಾಯ್ಬೇಕು, ಅಥವಾ ರೀಚ್ ಆಗದೆ ಹೋದ್ರೆ ಸಾಯಂಕಾಲ ಹೇಳ್ಬೇಕು. Yes. ಬಾಕ್ಸ್ ಕನ್ನಡ ಬರೆಗಿದೆ. Number 37. Number 37 na. ಹಾ
ನಾಳೆ
46 ಕಾಯ್ತಿದ್ದಾರೆ ನೋಡ್ರಿ ಅವರು. ನಿನ್ನೆನೂ ಬಂದ್ ಕಾದ್ರು, ರೀಚ್ ಆಗ್ಲಿಲ್ಲ ಅಂತ ಹೋದ್ರು. ಹೇಳಿದ್ದೀರಾ ಅವರಿಗೆ 46 ನಲ್ಲಿಯೂ? 46 ಸಿಕ್ಕದೇ ಇದ್ದಾಗ ನೀವು ಮೂವ್ ಮಾಡಿ ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್ ತಗೊಳ್ಬೇಡಿ. ಅವ್ರು ನಿನ್ನೆಂದ ಇವತ್ತಿಗೆ ಕೇಳಿ ಹಾಕಿಸ್ಕೊಂಡಿದ್ದಾರೆ. ಹೌದ್ರಿ, ಅವ್ರು ಬಂದಾಗ ಹೇಳಿ, ಅದನ್ನ ಅವ್ರು ಹೇಳಿದಾಗ ಮೆನ್ಷನ್ ಮಾಡಬೇಡಿ. 36 ನಲ್ಲಿ 37 ನಲ್ಲಿ ಹೇಳಿದ್ದೀರಾ? ರಿಕ್ವೆಸ್ಟ್ ಆಫ್ ದಿ ಲರ್ನೆಡ್ AGA for around or 4. A week's time as spread is granted. Yes.